Test. Did you hear me? Test.
Okay, we will return this meeting to order. Thank you for your patience. We did have a power outage this morning, so we I think may have some lingering resetting items and things. So thank you for your patience while we dealt with a little bit longer of a break than we anticipated. Okay, we are on to item 9.
Item number 9 is a special district service plan, Falcon Field Metropolitan District, Falcon Field Residential Metropolitan District 1, and Falcon Field Residential Metropolitan District 2. A request from Isinogle Seaver Pogue PC for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for Falcon Field Metropolitan District, Falcon Field Residential Metropolitan District Number 1, and Falcon Field Residential Metropolitan District Number 2. The 57.67 acre area included within the request is zoned CR, Commercial Regional, RS 5000 Residential Suburban, and RM 12 Residential Multi-Dwelling, and is located immediately east of the intersections of Woodman Road and Highway 24. The service plan includes the following: a maximum debt authorization of $35 million, a debt service mill levy of 50 mils for residential, and a debt service mill levy of 30 mils for commercial, operations and maintenance mill levy of 10 mils for residential, and 5 mils for commercial, and a special purpose mill levy of 5 mils for a total maximum combined mill levy of 65 mils for residential, and a total maximum combined mill levy of 40 mils for commercial. The item was heard on the regular agenda at the July 17th, 2025 Planning Commission meeting and was recommended for approval with a vote of 5-0. There is no public opposition to the request. Multiple parcel numbers, Commissioner District Number 2, file ID 25002, Carrie Parsons, Principal Planner, Planning and Community Development.
Good morning. Get this ready for a short person here. Carrie Parsons with Planning and Community Development. All right, thank you, Ms. Allred, for the introduction. If there's anybody that is watching remotely and would like to participate, if you could please email, we will get you in the queue for the hearing for participation. General hearing procedure, just for those in the audience or watching. And specifically, as Ms. Allred read into the record, this is a request for an amended and restated service plan amendment for an existing district and the creation of 2 new districts under one service plan. So the total area would be 57.67 acres for the sum of the districts. And again, a maximum debt authorization of $35 million for the sum of the districts, 30 mils for commercial, 50 mils for residential, an O&M or operation and maintenance of 5 mils for the commercial and 10 mils for the residential. However, of that O&M, out of the special purpose, 1 mil will be designated to Woodman Hills Metropolitan District per their inclusionary agreement for the ownership and maintenance of any park and recreational facilities that Woodman Hills Metropolitan District should own and maintain within this future development. Any questions on that? I know that that's a little bit of an oddity, and the applicant is going to go into a lot of detail to cover that. So, but I can try to explain anything higher level if we need to, because it is so unique.
Questions from commissioners? Looks like we will wait for that explanation from the applicant. Thank you.
Okay, I'm out of the hot seat for that one. Mandatory criteria for disapproval, and then the discretionary criteria was handed out to the commissioners for review. And the purpose of the district is very typical in this manner, all under the statute, with the exception of number 11. This is somewhat new before us, and that's the business recruitment, management, and development powers that the district is asking. Again, I'm going to ask the applicant to go ahead and dive into the rationale of why they need to ask for those purposes within the districts amended and restated, and those 2 new districts under one service plan. A little bit of history, as Ms. Allred noted, this property is now rezoned. We've got a commercial portion rural residential portion and a multifamily portion of this development east of Highway 24 in the heart of Falcon. The Board of County Commissioners did approve that preliminary plan for the commons at Falcon Field, which included 74 single-family residential lots for RS 5000 or urban development, and then 95 single-family lots in the in the residential multi-dwelling district, so more high density in that component of the project. And then 169, I'm sorry, back up. I just went too fast and got backwards. I'm gonna start over. I apologize. 74 single-family lots, RS 5000, typical urban development. 95 single-family residential lots in a multi-dwelling district with 12 dwelling units per acre. So there's a total of 169 residential single-family lots, a mix of urban and high-density single-family lots, and we have commercial as well. A picture of that zoning, so standard, typical development, the RM12, and then that commercial regional pocket along that Highway 24 corridor as Woodman Road tees into that. Current existing mill levies on the site, about 108 mills. The existing district, the Falcon Field Metro District, is about 148 mills currently. And so district number 1, as it is proposed, would then come to about 173 mills, as would district number 2 as it is proposed. In terms of the master plan, conformance with the master plan was made at the time of rezoning and at the preliminary plan. When we're looking at a special district in conformance with the master plan, we'd like to cite that the master plan encourages that development pay for itself. So special districts are a very common financing tool that developers utilize to make that happen. So staff has cited that in the master plan and in your documentation for backup. In terms of the summary of application, there is not an existing district in the area that is capable of providing the design, construction, and financing of the proposed public improvements such as roads, availability to design, own and maintain detention, provide utilities, with the exception of the Woodman Hills Metropolitan District, which does provide water and wastewater and parks and rec services. This developer has been working with Woodman Hills Metropolitan District and has obtained an inclusionary agreement. And that is why I mentioned that that designated 1 mills of that special purpose 5 mill levy will go to support the Woodman Hills Metropolitan District to maintain any parks and rec within this proposed district, as well as Woodman Hills Metropolitan District will own and maintain the water and wastewater infrastructure after the districts within the service plan before you today design, construct, and build that. Then Woodman Hills would accept that infrastructure for ownership and maintenance and provide water and wastewater services. The nearby Falcon Highlands Metropolitan District doesn't have the financial capability to provide services at this point in time. And staff is not aware of where they are in terms of moving forward to resolve their district's problems in terms of those financials and obtaining water. The overlap consent resolution and inclusion into the service agreement is within your backup, and so you should have that for your review. Again, reminder, we're talking about a $35 million maximum debt authorization, which is about $22.3 million in estimated public improvements for today's dollars. So it's very typical that an applicant is going to put some padding in there for inflation and unexpected costs that may arise during design and construction, which pushes that up to $35 million from the 22.3 at today's cost price. The applicant has provided a financial plan that identifies the applicant's ability to pay off the debt. I have asked the applicant to be very specific in discussing the bonds, the bond payoff, the debt payoff, the refinancing, and that maximum debt of 40 years in their service plan. But I'm just going to briefly touch base on it for the record from staff, so you hear it from staff. So in this year, the state has adopted legislation that requires that special districts essentially cap out at a 40-year term of debt. So what that means is a bond still has that 30-year max in our service plan that it can live before it's paid off. However, it does allow the applicants and the districts to refinance that bond at a 5 or 10-year period, which we would anticipate here within this proposed service plan. But they can't have the overall debt exceed a 40-year term. So the residents there's a final ending to this, and it's not going to go on. So the state said we're going to adopt that. The state, however, made it effective in late summer, but they also made it effective with the caveat that said, hey, counties, municipalities, any new service plan that you receive after January 1st of 2025, you need to include that, even though the law isn't in effect until late summer. So the applicant has written that into their service plan before you today, so we see that 40-year term max. Any other questions on that?
Questions from commissioners? I don't think so.
Okay, awesome. So I'm going to ask the applicants to come on up. You're short too.
I am short. You don't have to change it. I think my heels are a teeny bit. Good morning, Commissioners. Alicia Corley from Icenogle Seaver Pogue, and it's my first time before you, so please indulge me. I'm a little nervous. Carrie did a great presentation, and I'm going to try not to duplicate, and I already can't. There we go. I'm here today on behalf of the applicant who's seeking an amended and restated service plan for Falcon Field Metropolitan District. It's already an existing district, and then creating 2 new districts within that existing Falcon Field Metropolitan District property. We're here representing the developer, PT Falcon Field, which is a Proterra company, and we have representatives, Mr. Andrew Biggs and other representatives of the company here, should you have some specific development questions that I'm not able to answer. We also have Lacey Knowles here from D.A. Davidson, the financial planner, in case there are math questions that a lawyer should not answer. Carrie's already shown you a vicinity map of where the property is located, Woodman Road and Highway 24. It's approximately 58 acres, and Carrie went through this, so I will be brief that there's already been a preliminary plan approved, CR zone for the commercial district, which is going to be that Falcon Field Metropolitan District, the existing district. We're going to shrink the boundaries down of that district, and then there'll be 2 new metropolitan districts created, Falcon Field Residential Metropolitan District number 1, which has that RS 5000 zoning, and then RM 12 zone for the Southwest Residential District, which is going to be Falcon Field Residential Metropolitan District number 2. The approval of the final plat for Commons at Falcon Field Filing 1, the commercial development, is anticipated next month, and then early next year, the developer anticipates approval of the Commons at Falcon Field Filings number 2 and 3 for the 74 single-family homes and 95 single-family homes. The timeline for the special district, after our hearing before you today, we would go to the court and seek an order for an election to organize the district, and a court order from the El Paso County District Court would be anticipated sometime in December, organizing the 2 new districts, Falcon Field Residential MD number 1 and 2. Here's a site plan which shows you the 3 districts in relation to each other and the improvements that are anticipated. And as Carrie had mentioned, this district, Falcon Field Metropolitan District, was formed back in 2000, approved by the Board of County Commissioners. At that time, the property was included into Woodman Hills Metropolitan District, and Woodman Hills Metropolitan District and Falcon Field Metropolitan District entered into an inclusion and service agreement pursuant to which Falcon Field Metropolitan District was going to construct water and sewer facilities and then dedicate those to Woodman Hills to operate and maintain. It also accounted for the special purpose mill levy that Carrie mentioned of 1 mill to operate any park and recreation improvements that were constructed by Falcon Field Metropolitan District. Since we have submitted this amended and restated service plan, we went back to Woodman Hills Metropolitan District and got their consent to the formation of these 2 new districts. If these 2 new districts are formed, they likewise would enter into the same inclusion and service agreement with Woodman Hills Metropolitan District. As I just mentioned, this is an existing original service plan that was approved by the county back in 2000 for 58 acres of commercial development. And our purpose here today is to amend that existing service plan because the original developer has since sold the property and the development plan has changed. It was originally anticipated to be a commercial development only, and now we will include residential and commercial development as outlined. Metropolitan districts generally are governed by Title 32, created to serve a public use. They promote the health, safety, security, and general welfare of the inhabitants. They're user pay. They fund public improvements through bond issuance, and then future property owners pay for those public improvements through a property tax payment rather than their initial home price. This allows for access to longer-term funding and lower interest rates through the issuance of tax-exempt bonds, and they are a common funding mechanism here in Colorado, as Carrie mentioned in her presentation. Here is an outline of the responsibilities that these districts would have initially to construct these public improvements. And once construction is complete of the water and sewer facilities, those would be dedicated to Woodman Hills, but these districts would have ongoing maintenance responsibilities for non-dedicated streets, and there's substantial drainage improvements that these districts would have to maintain, and then as well as performing covenant enforcement and design review for the districts. The criteria for special district service plans, here you have to comply with state statute, which we have done. In addition, we've used the model service plan of the county, and your staff has no concerns with the service plan that's been presented to you today. Carrie had mentioned the maximum debt authorization being requested is $35 million for an estimated cost of public improvements around $22 million. And this amount is a little bit larger than the actual cost of the public improvements anticipated at this time to allow for inflation, contingencies, and any changes that might occur from the time of approval of this service plan until the improvements are actually constructed. Carrie had also reviewed the mill levies. It would be 50 mills for the 2 residential districts for a maximum debt mill levy, 10 mills O&M for the 2 residential districts, 5 mills for the existing commercial district, and then a special purpose mill levy of 5 mills for the 2 residential districts, as well as the commercial district. Overall, there would be a cap of 65 mills for the 2 residential districts and a cap of 40 mills for the commercial district. These are requirements in your model service plan, which we contain an annual report and disclosure form, and then a disclosure to prospective purchasers, to let them know about the existence of the Metropolitan District, the mill levies and fees that they are able to impose, and then the services that they would provide. And this is another quote from the service plan that just clarifies that the development still remains subject to any land use approvals that's not being granted here today in connection with granting approval of the service plan. Carrie had also reviewed this new statute that was passed by the legislature this year, which requires a 40-year debt mill levy imposition term for residential districts for any service plans that are presented after January 1st of 2025. We do have this language included in the service plan. Your model service plan already contained a 30-year maximum period for debt, which is the amount of time that the bonds would mature and then become due and payable. But as Carrie had mentioned, if you refinance, you would have the ability to extend that 30 years. The new legislation imposes a total of 40 years for a debt debt service mill levy that can be imposed in a residential district. So at the end of that 40-year period, the bonds would terminate and residents would no longer be paying a debt service mill levy.
Commissioner Nelson.
So you're saying if they refinance, they then can access that 40-year limit, whereas as a county, we currently only allow the 30-year?
As a county, your model service plan only has a 30-year limitation on maturity of debt. But this service plan now contains the new legislation, which imposes a 40-year debt mill
So-
levy
So
term.
even though our model service plan as a county says 30, this new legislation trumps that? Or are they still restricted to the
They're
30?
two different concepts. It's not the same thing.
Okay.
So if you have a 30-year period for debt, it's when the bonds would become due. But the district could refinance that, and then the debt could go on beyond those 30 years. So this is an additional limitation which won't allow any debt, even regardless of how many times you would finance or for how many years, to go beyond 40 years for any residents.
I thought as a county, we still only limited it to be that 30 years. Am I incorrect in remembering my orientation training?
Yeah. Maybe we want to have staff answer that portion of the question if you would prefer.
Sure.
Good morning. Okay, so currently, what in a nutshell, the district takes out a loan, and cannot last. The term of the loan can't be more than 30 years. But what happens most of the time is a district will refinance that loan at 10 years to another 30-year loan to get a reduced rate.
Okay.
And so they can keep doing that
Okay.
over and over. And so now the state has said,
limitations on that.
hey, let's put some provisions in to protect those residents so there's an end in sight for that debt. Now, the special purpose for covenant enforcement, in this case, the 1 mil, and the ownership and maintenance of those public improvements that the district's going to continue to maintain, that will continue on. So that's about 15 mils. But the overarching, the remainder, the 50 mils, that's stopped. So at 40 years, in theory, their tax bill should go down at the end of the day.
Okay,
Is that
I
cleared up?
had it wrong in my head. I thought that we as a county were even more strict and didn't let them go past the initial 30 years, regardless of refinancing. So thank you.
These are the statutory criteria that Carrie has distributed to you. So you must find that these statutory criteria are met, and we represent that we have met these statutory criteria today for you to approve the service plan. The first one is that there's sufficient existing and projected need for service in the area to be serviced by these proposed special districts. There's a demand for commercial and housing in this area, and the county has already approved a preliminary plan. These districts would undertake the construction of the public improvements necessary for residents and users of the commercial area. These districts would also perform continued maintenance of improvements that aren't dedicated to other entities or the county, and then provide covenant enforcement and architectural design review in the absence of a homeowners association or owners association. Criteria number 2, the existing service in the area to be served by the proposed special districts is inadequate for present and projected needs. As Carrie had mentioned, there are no other entities that would consider it desirable, feasible to undertake the construction of these improvements that are needed for the development of this property. The district would provide the funding for the construction of the initial improvements and then the continued maintenance of the public improvements. Criteria number 3, economic and sufficient service. The proposed special districts are capable of providing economic and sufficient service to the area within the proposed boundaries of these districts. The estimated future costs are in line with comparable districts, and I have a slide that I'll show you next that shows you where the mill levies fall with comparable districts. This would reduce the home price for these districts, and these districts, as I've mentioned several times, will continue to provide maintenance for those improvements that aren't being dedicated to Woodman Hills or the county. And this is the slide that I mentioned that shows you can see where the 3 districts are highlighted. And the last criterion, which you might,
Could you go back to that slide again
Yes,
for just
yes.
a moment?
I'm sorry.
The text is pretty small, so it's going to take my eyes a minute to see
Yeah,
that.
I don't have any way to blow it up. I'm horrible at PowerPoint. Can I increase it? Would that help? Nope. Made it worse, right? Stop touching it.
Everybody good to move forward? Thank you so
So
much for
sorry,
accommodating.
yeah.
No, that's okay. Thank you
Just
for
got my
accommodating
first
us.
pair of reading glasses. And this was the last criterion. The area to be included in these districts has or will have the financial ability to discharge the debt, and that's the financial plan that's attached to the service plan. And I have a slide which details this a little bit more. And then we also have, as I mentioned, a representative of DA Davidson, should you have any additional questions. The financial plan attached to the service plan anticipates an initial debt issuance in 2027 and then a refinancing in 2037. We have a chart here that shows you the revenue and the debt service to demonstrate that the revenue of the districts would be sufficient to retire all debt. And then the impact to the residents is approximately $2,300 a year based on an average home price of $520,000. And next steps, after our hearing today, we would ask that you approve the service plan without any modification. We would go to the district court, as I mentioned, to call an election in November of 2025, and then we would anticipate formation of the 2 new districts sometime in December. As I've mentioned, this is already an existing metropolitan district, Falcon Field Metropolitan District, so we're just creating 2 new districts today. And I'm happy to answer any questions or pull up my friends if needed.
Okay, are there questions for the applicant at this time? Okay, thank you so much.
Thank you.
And we'll ask staff if you have anything additional you need to add. Okay, so we'll move on to public input. Is there anyone here who wishes to speak in support of this application today? I see none in the room and none online. Is there anyone here who wishes to speak in opposition today? I see none online and I see none in the room, so we will move forward. If the applicant would like to add anything, there really doesn't seem to be anything to rebut, but it seems like you don't have anything to add at this time. Okay. Okay, so I will just ask the commissioners again, do we need to bring up staff for additional questions? Okay. So with that, we will just go ahead and move to any discussion amongst commissioners or a motion. And this is in my district, so I will kick off the comments here. Generally speaking, the chair does not make a lot of motions, but since this is in my district, if there's no objection from the other members of the board. This is in my district. I really do find that this has been clearly laid out. Thank you for the excellent presentation, clearly laying out the need and all of the pieces of the criteria. So I do find that it meets our criteria to do that. I'll just make some general comments. I also appreciate, especially because we have some newer commissioners, the sharing of the information about special districts. That's also usually also very helpful for the community as well, that these are a necessary part of making sure that development does pay its way in our community. And though not perfect, we see that that there are continual improvements, which I appreciate. I appreciate Commissioner Nelson bringing up the the difference between, financing that 30-year loan essentially, and then this limitation that the state has recently put in, so that does not go on forever. And I especially appreciate you pointing out that it can reduce the cost of new home ownership. That's a really key part of this as well, is that it is essentially kind of the mortgaging, if you will, of the public improvements there. So thank you for the good presentation. So with that, I would be happy to make a motion to approve this Metro District.
Second.
Okay. Did you want to make comments, or are you just getting ready for the vote? Okay.
Getting ready.
So that has been moved and seconded, and if there are no additional comments, I'll go ahead and call the roll. Commissioner Weissong.
Aye.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams.
Aye.
And the chair votes aye. That passes 5-0. Thank you. And I think with that, we can move to item 10.
Item number 10 is a special district service plan, Stonebridge Metropolitan District numbers 1 through 6. A request from Whitebear, Inkley, Tanaka, and Waldron for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for Stonebridge Metropolitan Districts numbers 1 through 6. The 160-acre area included within the request is zoned RR5 Residential Rural, RS 5000 Residential Suburban, RM 12 Residential Multi-Dwelling, and RM 30 Residential Multi-Dwelling, and I3 Heavy Industrial, and is located north of Cowpoke Road, east of Black Forest Road, and south of the future extension of Mark Scheffel Road. The service plan includes the following: a maximum debt authorization of $26 million, a debt service mill levy of 50 mils for residential and commercial, and an operations and maintenance mill levy of 10 mils and 5 mils for special purpose, for a total maximum combined mill levy of 65 mils. The item was heard on the regular agenda at the July 17th, 2025 Planning Commission meeting and was recommended for approval with a vote of 5-0. There is no public opposition to the request. Multiple parcel numbers, Commissioner District numbers 1 and 2, file ID 24001, Carrie Parsons, Principal Planner, Planning and Community Development.
Thank you, Ms. Allred. All right. Again, if there's anybody watching, if you would like to email, we will get you in the queue to participate in the hearing today. Ms. Allred read the request in, just for the record, this is the creation of a new special districts, 1 through 6, so 6 districts within the service plan is presented before you today. It's 160 acres. It does overlap Vollmer Road. So the property is located between Vollmer Road and Black Forest Road, which is going to be the residential component of that. And then the east side of Vollmer Road, south of Sterling Ranch development, is going to contain the more commercial components of the district. Looking at about a $26 million, you are looking at a $26 million debt maximum, both 50 mils for commercial and residential, 10 mils for ownership and maintenance of those public utilities like private roads, detention ponds, open space, and then 5 mils for covenant enforcement. Standard criteria as was passed out and attached to the staff report backup material. Here we're looking at the standard purposes of districts that you typically see. Solid waste disposal security services. I should mention that this district is proposed to have an IGA with FAWA, Falcon Area Water and Wastewater Authority, for central services for water and wastewater. And so what that means is the proposed districts would go ahead and design, construct, finance the water and wastewater lines and utilities, and then once it is completed, FAWA would accept it for ownership and maintenance. FAWA is an authority. It is not a metropolitan district. So here you can see that mix of zoning within the overall development. Sterling Ranch to your north here above Mark Scheffel. Mark Scheffel is now a city-owned right-of-way, and it actually does now connect down to Woodman Road. I believe it's almost finished being developed. This area here, for the most part, is industrial and commercial uses. There is a pocket of rural residential zoning. I would anticipate that coming in for redevelopment in the future. The multifamily development here, we anticipate receiving a final plat and site development plan submittal for some type of apartment complex here, which would trigger the pushing eastward, or excuse me, pushing westward of Mark Shuffle Road as a major east-west corridor. This district would be responsible for the contribution of design, finance, and construction of that Mark Shuffle Road improvement. And then it would continue forward. Here is Cottonwood Creek. The district at this point in time, we are not sure. We're not down to the detail to know what type of improvements we're looking at over Cottonwood Creek and along the banks of Cottonwood Creek. We would see that with the preliminary plan for that site. However, there are provisions in the district to be able to design, construct, and finance if these districts are created. So again, some history, as I mentioned. The zoning was approved by the Board of County Commissioners fairly recently, the last couple years. The overall Board of County Commissioners, the overall sketch plan for the property east of Vollmer, again, is within the Sterling Ranch development. The properties west of Vollmer are not within the Sterling Ranch development area. So current mill levies for proposed mill levies for districts numbers 1 and 5 would about be 138 mills max. Currently, those areas for District 1 and 5 are about 73 mills today. District 6, you're looking at about 70 mills today, 70.7 mills today for taxes, but if created, jumping up to about 136 mills if approved. Again, our master plan identifies that development should pay for itself. Districts are that financing mechanism for developers to do that. Summary of the application. This district is within several adjacent districts. However, those districts, the applicant has said that it is not desirable or feasible for the districts to undertake those roles that these districts would do design and construction. Again, this district would also incorporate the new statute limiting that 40-year maximum. So there is this end of the story to the debt for the residential residents within the district. And you would anticipate seeing that refinancing of that initial bond to benefit from a reduced interest rate at the 10-year mark and refinancing for that additional 30. Any questions on that? We do have the financial folks here to talk to that specifically. With that, we are anticipating, based on the financial plan, that there will be a PIF. So there is a 2% add-on fee expected within the commercial areas here for any retail sales, and that will go towards paying those bonds down, specifically noted in the service plan as requested by staff. Are there any questions for staff, or should we have the applicant come up?
I think we're ready for the applicant. Thank you. Actually, before you do go away, I do have a question about the PIF, and we can have the applicant answer if you want. But is there a time limit? I mean, obviously, in the in other debts that are in the service plan, there's a time limit. Is there a time limit on the PIF, or will that exist in perpetuity?
I don't know the answer to that, Chair. I'm
Okay.
hoping the applicant will. If not,
Great.
I'm going to, Lori, if you're listening, I'm reaching out.
Thank you. Okay, now I think we are ready for the applicant.
Hi, Council. Erin Stutz with White Bear Ankley, Tacoma Waldron on behalf of the applicant. Make sure I got slideshow here. Okay, so in front of you today, as Ms. Parsons mentioned, we've got a consolidated service plan for the Stonebridge Metropolitan District numbers 1 through 6. The service plan is submitted pursuant to statute discussions with county staff, and then, of course, the county's resolution 22-376 for special districts and the multiple district without control district model service plan. So that's the service plan you're looking at today. Carrie went over this a little bit as well. The projected area is about 136 acres. We've got several product types going in, 160 single family detached, 390 residential apartments, and then 390 single family attached units, and about 150,000 square feet of commercial and industrial space. So we're asking for a multi-district structure. The purpose of this structure is to allow the districts to complete construction in phases as the development goes and completes. So we've got 4 districts for residential, 1 through 3, and then there's the 4th, which is an overlay district, and then there's District number 5, which is anticipated to be commercial, and District number 6, which is anticipated to be industrial. So the overlay district is an operations and maintenance district. So that'll go over those 3 districts, 1 through 3. That'll handle owning and operating the public improvements once they are constructed. The 3 residential districts that are underneath that overlay district will handle the financing and the construction of the improvements within those districts. So the overall purpose and benefit of this structure is it allows operations and maintenance services to have continuity over those 3 areas. So ultimately, when you do have residents move in, those residents can be both on the board of the financing district and the operating district. So all 3 districts will have the opportunity to be on the operating district and be able to, work together for those operations and maintenance services. In accordance with the service plan, District number 4 will not impose a debt mill levy on any property that Districts 1, 2, and 3 impose a debt mill levy. So there will not be overlapping debt mill levies at any point in time. Are there any questions about that? Okay, so other overlapping entities, we've got Falcon Area Water and Wastewater Association, and then Black Forest Fire. It's anticipated the districts will enter into intergovernmental agreements with both of these entities. Once the improvements are constructed, they will go to these entities for ownership, operations, and maintenance. So here is the map. The public improvements that are anticipated are, at the moment, roadway, water, sanitary sewer, stormwater and drainage improvements, parks and recreation, and landscaping. Estimated cost of public improvements is approximately $18.5 million. Any improvements not funded by the districts remain the responsibility of the developer, and the county is not responsible for the cost of the improvements funded by the districts, any issued debt by the districts, or the developer's development costs. The financial plan shows that the total debt of the district shall not exceed $26 million. Same as what we talked about with Carrie, the maximum mill levy imposition term is 40 years, which we've already discussed. The districts anticipate issuing a series of bonds. We were anticipating at the end of this year, it could roll into next year in the amount of $19 million. Under the financing plan that was attached to the service plan, it shows that the districts will have the tax base to support these issuances. Total cap for the districts on the property is going to be 65 mils total. So we've got the debt service mill levy cap of 50 mils. You've got an operations and maintenance mill levy cap of 10 mils, and the special purpose mill levy cap of 5 mils. The special purpose mill levy cap is going to go towards covenant enforcement. And as I stated before, District number 4 will not impose a debt service mill levy on any property that districts numbers 1, 2, or 3 impose a debt service mill levy. So we've got safeguards in the service plan to protect against that. So there's no overlapping mill levies between those districts. Bond structure and repayment. So as I stated, we were anticipating December 2025, possibly later. 30-year term on the loan, which is in the service plan as well. final maturity of 2055. The 2025 bond issuance will be issued as an early stage issuance, so there will not be it's anticipated that when these bonds are issued, there will not be any end user homeowners residing in the district at that point. Early stage bond issuance will require analysis by outside independent consultants. So a market study will be required, a financial forecast will be required, and then the early stage bonds are marketed to institutional investors only who have experience with these type of bonds. So that creates another level of protection. Surrounding mill levies in the area, there is, as you can see here, Stonebridge is right towards the bottom of this list. Additional safeguards in your service plan. We've got the disclosure notice to purchasers, the annual report to the county. If there are any changes to the service plan, the county requires us to come back in front of you all for any change in the base services, any issuance of debt in excess of the maximum debt authorization, a debt mill levy cap increase, creation of any sub-districts, and then inclusion of property over 5 miles from the combined area of the districts. So just as a wrap up, the benefit of the metropolitan districts, as we have discussed today, is to fill the void. So there is no other public entity that finds it desirable, feasible, or practical to fund these public improvements. That is one of your categories that you need to, or the factors that you need to consider for today. The existing service area to be served by the districts is inadequate for the present projected needs, so that is why we need the districts. The districts reduce the cost of public improvements by allowing a low-cost tax-exempt financing option, and then it's proportionate, rather than front-loading the costs of public improvements on new home sales, the costs are paid via the property, the tax-deductible ad valorem taxes and the property mill levies for a term not to exceed that 40 years, as we discussed. As we also discussed, the districts are able to provide economical and sufficient service for the project. And then the area included into the districts does have and will have the financial ability to discharge the proposed debt. Are there any questions?
Vice Chair Williams?
I do have a question. The public improvement fee is a sales tax, correct?
It's a private covenant on the property.
And how long will that last?
So that
In
can,
perpetuity?
for what I understand, so the district doesn't impose the public improvement fee. That's a fee that's negotiated with the property owners. But the public improvement fee can go towards paying the debt of the bonds later. So once the bonds are paid off, the public improvement fee can cease because there's nothing.
So once the bonds are paid off, does the public improvement fee go away?
Potentially, yes. But again, it's not something the district imposes.
Is it then the HOA that imposes it? It's the homeowners,
I believe,
guess.
yeah, I
of the-
believe
Or
so.
the property owners.
Mhm.
Okay, I have some questions for staff on that one too.
Okay, I'll start with Commissioner Weissong, and then we'll go to Commissioner Nelson after.
I don't know what number this is, but under your public improvements, it starts off with, if you want to go back maybe 4 or 5 slides, you had a couple slides more than we did. There you go. The extension of Mark Shuffle to tying it back into, I believe that was research. Is that going to be covered by the Metro District?
Yes.
Okay.
Yeah, it's anticipated that number 3 will take care of that. We'll finance and construct that road. And then the districts will also have a intergovernmental agreement between them, the 3 residential districts, 4 residential districts. So that will, they will work on basically the cost sharing of that.
Okay, thank you.
Commissioner Nelson?
I would like to learn more about the IGA. And for those in the room that aren't aware, I received the appointment at the end of June, so I'm still learning, and I love to learn and ask questions, so bear with me. The IGA with the fire district. Can you go back to the slide? I think it was number 8. Yes, this one. So when you enter into that IGA, is part of that going to be the operations and maintenance mills will contribute towards the cost that fire district now will be helping cover this area? And this is like way in the weeds, I realize.
Yeah, no problem at all. No, great question. No. So once the improvements are turned over to whatever entity will take those, that entity may impose their own operations and maintenance mills. So I think, I believe Black Forest already does impose mills on this property.
Okay, the
So-
fire district of, got it. Okay,
Yeah.
thank you.
Okay, additional questions for the applicant? I do have a few questions around the PIF specifically. The portion under which this falls underneath that covenant. I understand that it is not you that is imposing it. Wouldn't be the Metro District that's imposing it. It's the Metro District who is essentially performing the function and enforcement. What is the enforcement on that currently, and what is the organization? Has that organization been formed, and what is the name of that organization?
I think this is so early in the development process that none of that
Okay,
has
so it
occurred
will
yet.
be formed, and we just don't know what it is.
Correct.
This is part of always my concern with these is there's a lot of unknowns about what that looks like. It's a tricky piece, and I get very concerned when we start have government enforcing private contract, to your point of not being able to answer that. So because the service district is government, you have a private contract. It's always, and we see it all the time, but it is concerning to me, and it's always more concerning to me in situations where we have something like a PIF that's being imposed. Because it seems a bit more nebulous to me exactly how that's going to all be done and how it works. A homeowners association, we're all pretty familiar with that. We kind of understand who sets the covenants. This one, not understanding what type of organization it is, how it could be formed, leaves a lot of opportunities. Certainly understanding that folks would still enter into that through a private contract so that there's a choice in that, but it's still without having any kind of understanding of how that would be utilized compared to a residential where it's, we're just more familiar with those. It is a bit concerning to me. Doesn't mean that I'm unwilling to approve the district, but if you have any additional information about kind of how that would work, that would be helpful for me. And if that's not, and if you don't have it at this time, maybe just the parameters, and I can ask staff about what the parameters of that could look like or what we've seen look like in other applications.
Sure. So as I stated before, like a PIF is a private covenant. So the district actually wouldn't be enforcing that either because the district's not imposing it. So how the district gets those mills would be through an agreement, or it's not those mills, excuse me, those fees would be through an agreement with that private entity. And it's the private entity that's required to enforce that.
Okay, so a
And-
bit different than how metro districts can enforce the covenants of other, like that we've seen in other homeowners. I'm looking at our staff for a nod. So it is a bit different than there's no enforcement then.
That's my understanding, correct?
Okay, so it's just allowing it to be introduced as a form of payment on the debt.
Exactly.
Got it. Thank you very much for that clarification. Okay, with that, I'll just make sure. Yes, go ahead.
I just do have some questions for Carrie or Megan. It's going to involve this PIF.
I'll do my best, but if I don't know, I'm going to tell you I don't know.
I don't know as if you can answer it or not. So what I'm troubled about, I'm familiar with how the city uses public improvement fees. So if I go to the Chick-fil-A on South Nevada, I'm paying an extra 6% in sales tax. I do know that. My biggest concern on the public improvement fee is after 30 years, does it stop being collected?
It's my
Or
understanding.
40, 30 or 40, whichever we're talking.
Understood. It's my understanding, I'm chatting with Ms. Segal, I phoned a friend, and we don't, she took a glance at the statute and it doesn't say that it terms. So it in theory could go on.
And do we have any regulations around that? Because if we take the roads over from a special district and we're using the operations and maintenance mill levy or the special service for the HOA, where does this 2% go to? It darn well better go back into paving, my parking lot at the Safeway and Wells Fargo where I go frequently, or it shouldn't, once the debt is paid, it needs to stay within the public improvement area. I don't think it should, my concern is it considered extra income for the developers in perpetuity? Because it is a tax.
I can't answer that.
Okay.
But I would, in theory, the O&M, the operation and maintenance, and the special purpose is going to go on. So it would make sense and be logical if the PIF were to continue that it would contribute towards that.
Yeah, and that's what I would
we-
want to see in the future is to make sure that that PIF continues to go back into the operation and maintenance of the property. And maybe this is just the first time, I've ever noticed a PIF in here. We have approved them before, but my concern is establishing a sales tax in a specific area in perpetuity. One, it's a mess for the State Department of Revenue, but two, it affects one of our very key income sources, which is sales tax revenue. I think that individuals who are buying new houses are very used to looking and seeing, I've got 135 mil levy. After they get into the house, they figure that out typically. And they might see our road impact fee in there as well. But when they go to, if they did when I was young, when they go to the Wendy's or the Chick-fil-A, they're not going to see that PIF. And I want to make sure that PIF in the future, not today, but I do want to see that always stay in the operations and maintenance for the special district. So that, because if we're taking over county roads, then those better be going into sidewalks and pavement and stuff like that within the special district and not becoming something different. So maybe we need to see, legally we can have Lori write a memo. I know that probably made the county attorneys smile over there, but just to see where it goes in perpetuity, because I'm real curious on that one.
May I read some language that Ms. Segal just sent me?
Sure.
Okay, this may help or it may make it worse. So public improvement fees, PIFs, they're not a sales tax. They are not administered or collected. In this case, the City of Colorado Springs is where she's getting her reference from, so the county would not be collecting this. Most often, PIFs are a private fee that developers require their tenants or purchasers to collect from their customers. So as you mentioned, Chick-fil-A on South Nevada, you pay that extra tax and it doesn't go towards revenue towards the public interest or the city or the county. The fee is collected as part of the sales transaction, is generally a percentage of that sales amount. The developer property owner may normally implement a PIF without municipal approval or county approval in our case. The PIF may be used for any designated purpose, but is generally used to pay for infrastructure, on-site improvements, and maintenance of those improvements. The fees must be listed on the sales receipt as a separate line item from the actual sales tax. So as to your question,
And some of us, on occasion, look at those receipts. So,
your question, can staff force the applicant to designate the funds? Ms. Segal does not think we can do that under the current regulations.
okay, but it does sound like, I'm very familiar with how it is used in the city. So it does sound like it's going back into the infrastructure, and that's the important thing. So with that, I'm okay with that. Thank you.
Yes, we have had other special districts before this board that have implemented a PIF and a RIF. So I think we're going to see a bit more of those coming up shortly as well.
Commissioner Nelson.
I have two questions. more comments or thoughts. Just when you read that and it spoke to the developer being involved, that makes me think that then it wouldn't go on in perpetuity, because once those bonds are completed, isn't that then when the developer sort of exits this situation? And so is that true or not necessarily?
I think you're talking about,
if
and-
it's
and
the
to the point that
developer
you're saying-
collecting the money.
but the developer will own the properties potentially that, let's say, I don't know, I'm kind of guessing here. We can ask them to clarify if I say anything that doesn't make sense for this project. But generally speaking, if you have commercial area and you have commercial tenants, they may be tenants, so they may not own those properties. So the developer
Okay.
may continue to own the property and lease it forever, and they will always be there.
Okay.
It's the Metro District that's separate. And this is where I say I get a little nervous, because it's really hard to kind of start separating those things. Understanding it's not a legal sales tax, and yes, at any point, any property owner who is leasing to their tenants could say, hey, we're going to impose extra fees on customers. We're going to put that on a receipt. It's not a tax at that point, though it certainly appears to be one. And because it's paying for public improvements, I think we're playing a little bit of semantics. Nevertheless, if it were not collected as a PIF, it could also just be that the developer goes to those tenants and says, we're going to charge you $200, $300, however much more in rent, and could be collected in a different type of way to help offset those public improvements. So I think it's a lot of semantics about how it's done. In this case, it's very public facing to the customers, which is maybe a good or bad thing depending upon your opinion on those. So, but that's kind of the developer piece, is they will still own. I mean, the Metro District or Special District is just a governmental agency that is managing all of that public infrastructure at that point and paying off the debt. But that doesn't mean that there still aren't private property owners. As similar as you can live in a Metro District as a residential homeowner, you can do the same in a commercial. And you can feel free to say, I did any of that wrong, applicant, if you'd like, but that's kind of my.
And that's dependent then on the developer maintaining ownership of those commercial properties. I was thinking Chick-fil-A would own their building. And
I guess it could go either way.
yeah,
Yeah, and I think that the point is rooftops, the houses always go in first. About 10 years later, the commercial starts filling in. And so if you're going to a specific parking lot all the time, which is my Safeway, which has my bank, my dry cleaners, and my mailbox, and you start hitting potholes and they're collecting a PIF, they better darn well be using that PIF to fix those potholes, because that's, in my mind, that's what it's for, is to fix the potholes. But I think over time, that PIF goes to keep the facility looking nice, the parking lot working, any handicapped upgrades, they have to do those kind of things. For example, when I went to the state fair, maybe the state fair needs a PIF because their parking lots haven't been paid for 30 years. And, you could literally lose your car in that pothole. And so that's just my point, is this is the first time I've just really, that's because I'm used to the 10 mills, I'm used to the 5 mills, and that's the first time that's really popped for me. So that's been interesting.
I think the other thought that I had on this was, I know in statute, it's changed over recent years that there are expectations of clearly communicating to homeowners about that you're in a Metro District, that means more mills. So then hopefully that communication is also clear to the retail, commercial property owners or leasers, that when you sign up to rent this building, you're also signing up for an extra additional tax fee on your customers. So hopefully that communication is happening.
I think we can let staff answer, and then if the applicant has additional questions that I would assume, because they're contracts, that they're very similar, but go ahead.
Okay, so again, thank you, Ms. Siegel, for listening in and kind of helping me explain this. So the PIF, that private fee, is going to be established through the covenants of the commercial development. So the developers established in those covenants, when they go through the final platting process, a leasee or a buyer understands there's covenants, they know that they have that PIF. The district, however, has the authority to, under the special purpose organization of this district, to manage the covenant enforcement. So the district isn't running the PIF. However, the district is managing the covenants. So it's a big
So
loop.
there is potentially enforcement. So the applicant is saying they don't intend to enforce, but there is the potential underneath the Metro District plan for there to be enforcement of that, is what it sounds like. And this is the part that is always a bit difficult, but when we, as I said, when we start getting into the public and private. But I appreciate the clarification that the service plan does authorize them to, whether or not they intend to.
Right. And I just wanted to be very clear that covenants are enforced by this district as proposed, and the PIF is essentially created by covenant. So, anything else?
But we do have it on record that the applicant says they do not intend to use the district to enforce. So I appreciate that. Thank you. Okay, so we have heard from the applicant, had some additional questions from staff. I just want to make sure that you didn't need to clarify anything from the applicant before we move forward to public input.
No, I mean, I think you got most of what we discussed, and thank you so much. Great recitation of what a PIF is and what it can do. Exactly what you said in terms of whether or not the district will enforce or will, well, first of all, whether the district will impose. No, the district doesn't impose it. As we said, it's a covenant. Whether the district will enforce this, the district has the ability under the service plan. At this time, it's so early on, we don't know. It's not anticipated, but we don't know.
Okay, thank you. Thank you. Okay, so with that, we'll move to public input. Is there anyone here who wishes to speak in support of this application today? Okay, seeing none in the room and none online, we'll move to opposition. Is there anyone here who'd like to speak in opposition of this application today? Seeing none in the room and none online, we will move to any final questions from commissioners of staff. I think we've probably mostly covered everything. Okay, so we will close the public hearing and we'll just move to discussions and decisions from the commissioners at this time.
I find that the special district Stonebridge meets the requirements, and I would move approval of item number 10.
Second.
Okay, that's been moved and seconded. Any additional comments? I would just make my final comments. I really appreciate the clarification on this. This continues to be something that is just a little bit messy for me in the world of special districts. However, it is part of our plan. It is something that we have done consistently, so I won't be seeking to, change things here midstream. I'll be in support of this. It's one of those things that we just continue to work with, how those things can best function and we can best protect everyone involved in the situation. So with that, if there are no additional comments, I will call the roll. Commissioner Wysong.
Aye.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams.
Aye.
And the chair votes aye. That passes 5-0. Thank you. Okay, we will move to item 11.
Item number 11 is a special district service plan, Monument Ridge Metropolitan District numbers 1 through 3, a request from White Bear, Ankley, Tanaka, and Waldron for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for the Monument Ridge Metropolitan District numbers 1 through 3. The 64-acre area included within the request is zoned RS 6000 Residential Suburban and RM 12 Residential Multi-Dwelling, and is located east of Monument Hill Road and south of County Line Road. The service plan includes the following: a maximum debt authorization of $20 million, a debt service mill levy of 0, 25 and 50 mills for residential, and an operations and maintenance mill levy of 10 mills and 5 mills for special purpose, for a total maximum combined mill levy of 65 mills. The item was heard on the regular agenda at the July 17th, 2025 Planning Commission meeting and was recommended for approval with a vote of 5-0. There is no public opposition to the request. Multiple parcel numbers: Commissioner District Number 1, File ID 24005, Carrie Parsons, Principal Planner, Planning and Community Development.
Thank you, Ms. Allred. Carrie Parsons, Planning and Community Development. Again, if you're watching and you would like to participate, please email the email on your screen and we will get you in the queue. This is a specific request for the creation of the Monument Ridge Metropolitan Districts 1 through 3. There is a portion of the district in the lower portion that does overlap with the existing Misty Acres Metropolitan District, west of Misty Acres Boulevard, east of I-25. However, the applicant has obtained a resolution as of August 21st from Misty Acres Metropolitan District Post-Planning Commission for the exclusion of that area for this district. The special districts are requesting a debt total of 20 million max. There is a zero mil for district number 1 being a residential district, 50 mils for residential number 2, and 25 mils for residential district number 3. The reason district number 3 is so low is because there is already an existing Misty Acres mill levy on that portion of the property. So to balance everything out in terms of what people are paying at the end of the day annually on their tax bill, they'll pay down that existing mill levy debt through Misty Acres in district number 3 if created, and then they'll have that new 25 mil that they're paying towards the new creation of the new district for the improvements that this developer and the district will design and construct. Again, this one's a little bit unique before you today. Are there any questions on that?
Vice Chair Williams.
Whew, that was a lot. So the existing mill levy in Misty Acres, do we know what it is? Is it 65?
I think it's 35, ma'am. And I'm
Okay.
going to get a head nod from 30. 30.
30.
Sorry.
Okay, that's the important thing. I just didn't want them really to go over the 65. So thank you. Okay, we can keep going.
Okay. Criteria has been handed out and has now been posted for the record. Standard statutory purposes for the districts. History, this was a recent rezoning application. It's basically at the northern portion of the county, east of I-25. We have the rezone to multi-dwelling RS 6000, and we had the preliminary plan approval December of last year for this development, anticipating final plat approvals late 2025, early 2026 for their first phase of development. This district would be responsible for the movement forward or connection of Misty Acres Boulevard, as you see on the screen, to County Line Road. The districts would then be responsible for the design, construction, and of that development, removing Misty Acres as it exists, their districts today, from that responsibility. Misty Acres District was initially proposed and set up to do that connection. However, as you know, that connection has not occurred in the northern portion of the county, so this district then would be responsible to take that over as they pursue their development. Any questions on that? Okay. So again, we kind of touched on this. Existing mill levy for the overlap portion is about 96 mills. District number 1 and number 2, if created, we're looking at about 131.3 mills. Total mill levy, including District 1 and District 3, is 131.3, and that does include the obligation to pay down that existing debt to Misty Acres. And the applicant is more than happy to go into further detail on any financial numbers. Math in public, not a planner's friend. Again, master plan says developers should pay for their developments, not the county, so districts are the tool to do that some developers use. The overlapping special district, don't really need to dive too much into this because the Metropolitan District Misty Acres did agree, and that resolution was approved to exclude. So we would anticipate the court order to follow up to physically do that exclusion and wrap that up. Summary of the application. So there are no other districts in this vicinity. Misty Acres District cannot do the design, construction, and financing. It should be noted that Woodmore Water and Sanitation District, however, will extend, this proposed districts will extend design and construct services, water and wastewater services, then through an IGA with Woodmore Water and Sanitation District. Woodmore Sanitation District will take on that infrastructure, provide water and wastewater treatment for this development. So it's kind of the same deal that we've seen with the previous 3 districts, working out that IGA with existing districts that don't necessarily have the capability for the other types of public improvements, the road construction and the detention pond, open space, et cetera. The developer, or excuse me, the applicants have provided a financial plan analysis. It does include that 10-year refinancing at a lower interest rate, and they have incorporated that new 40-year full-term limit of debt into their service plan as requested by staff. I should note, for full disclosure, the applicant has listed in their service plan that they have the ability to propose fees. Staff did ask it throughout the review process to identify what those fees are, what they would be for. At this time, the applicant's service plan indicates that they do not have the ability to do that because they basically don't know at this time. But I wanted to be clear and on the record that this district also does intend to do that or have the powers to do that. It is in the service plan. Are there any questions for staff?
Commissioner Applegate?
So this request is coming up also because of, you said it was a rezone? Or
I'm
or
sorry.
did I missed that there. You said, because you said that they rezoned recently or no, or did they?
Oh, yes, sir. So this overall development had three rezones that occurred
Three
in
rezones,
a
okay.
preliminary plan that was recently approved in 2024 December, which meets our policies. So they have the underlying land use entitlements, so then their financial plan is based on those densities. Does that make sense?
Yes. That's
Okay.
what I was
I wanna make
and I
sure
was just clear, just for clarity. So say, okay, so they had zoned originally something else. They rezoned it this last year. And now they're asking again. They're saying now with the rezone. Yeah. Okay.
I'm sorry, I'm having a really hard, your mic's coming really fuzzy for me. I apologize. I'm having a
No,
really
I'm
hard
saying
time
because
hearing you.
they rezoned. They took 3. You said there was 3 different things they had, plots they had differently, and then they rezoned it last year. Correct? I'm following that. I'm tracking that.
Yes,
Okay.
there's an approved rezone and an approved
Yeah.
preliminary plan to the RS 6000 and RM 12.
RM12. Okay.
It was, I believe, commercial service in this little section right here.
Right.
And this section previously was RS 20,000 in the Dolewood neighborhood.
Okay. Perfect. Thank you.
Okay. Sorry about that. I was having a really hard time hearing you. Should I bring the applicant up, Chair?
I'm looking to see if we have any additional questions. Okay, I think we are ready for the applicant.
There's a lot of PowerPoints in there. I want to make sure I'm pulling up the right one. Yeah.
Commissioners, Aaron Stutz, White Bear Inkley, Tanaka and Waldron, on behalf of applicant. Good to see you again. Monument Ridge Metropolitan District numbers 1 through 3. Very similar slide deck as what I just showed you. So we've got submittal of this service plan pursuant to statute, discussions with county planning staff, and then also in substantial compliance with the county's model service plan. This project is 64 acres. It's planned to be fully residential with 340 residential units. It is a multi-district structure, very similar to what I explained for Stonebridge. We're going to have an overlay operations maintenance district over this property as well for the same purposes. The overlay will own, operate, and maintain the public improvements. And then the 2 financing districts will finance and construct those improvements. And just again, for the record, the benefits of this structure, it allows continuity of operations and maintenance over the entire project. And then also in this service plan, District Number 1 will not impose a debt service mill levy on any property that Districts Numbers 2 and 3 impose a debt service mill levy. So you will not have overlapping debt service mill levies. Overlapping entities, we've got Woodmore Water and Sanitation District, Tri-Lakes Monument Fire Protection District, and then last was Misty Acres. As Ms. Parsons explained, we did receive a exclusion resolution from Misty Acres. Misty Acres also provided a letter that stated that they are not willing or able to provide the services and public infrastructure needed for this project. Which is why they also ultimately consented to the exclusion. Under statute, this resolution cannot be effective until the district is organized. The purpose of that is to allow the property to continue to have some kind of district servicing that property until a new district is created. So once this district is created, we'll take the order, we'll provide it to Misty Acres, and then they can go ahead and file the exclusion order with the court and complete the process. Also, upon exclusion, so the property will be subject to Misty Acres 25 mil debt service mill levy. They currently impose 30, so it's 25 debt and 5 operations and maintenance. So once these districts take over, they will no longer get that 5 mills. So that property is no longer subject to their 5 operations and maintenance. So the total debt mill levy on this property or on that property will be 50 mils. So concurrent with the other property. Public improvements for this district or these districts will be roadways, water, sanitary sewer, stormwater and drainage, parks and recreation, and landscaping improvements. Cost of improvements is anticipated to be about $15.5 million. Improvements not funded by the districts remain the developer's responsibility. The county is not responsible for those costs of improvements. Any debt issued by the districts or developers' development costs. The maximum debt in this service plan is $20 million. Same same maximum mill levy imposition term of 40 years. The districts anticipate issuing a 2026 series of bonds and then a 2036 series of refunding bonds. And then per the financial plan, the districts will have the tax base to support these issuances. And then as you can see on the right-hand side, we've got the total debt mills here. So again, District Number 1 will impose the 10 and 5, so the operations and the special purpose. And then districts number 2 and 3 will have the debt service mill levies. So 2 will have 50 mills, and then 3 will impose 25, and then we'll have the 25 from the existing Misty Acres mill levy. And then just, again, District Number 1 will not impose a debt service mill levy on any property that Districts 2 and 3 impose a debt service mill levy. Bond payoff. So we have here a more detailed explanation of the bond payoff. Projected revenues are sufficient to retire the debt. And the impact, as you can see here, is about $2,800 a year, assuming a home price of $630,000. Additional safeguards. The service plan requires the disclosure notice to purchasers about the districts. An annual report will be filed with the county. Again, county approval is required for any change in base services of the districts, issuance of debt in excess of the maximum authorization, debt mill levy cap increase, creation of any sub-districts, and inclusion of property over a 5-mile radius. And then again, yep, no other public entity finds it desirable, feasible, or practical to fund these public improvements. Allowing the districts to move forward provides a low-cost public improvement financing for residents. And instead of front-loading those costs and public improvements, you've got these tax-deductible mill levies for a term not to exceed 40 years. Any questions?
Okay, no questions. Thank you. Great job. We will move to well, let me just make sure that we don't have any additional questions of staff before we move to public input. Okay, so we'll ask for anyone who is in support of this application, if they'd like to speak at this time. Seeing no one in the room and no one online, we'll move to opposition. Is there anyone here who'd like to speak in opposition to this application today? Seeing none in the room and none online, we will move away from the public input portion. And again, there's nothing to rebut here, so unless there's any last final words that the applicant has. And again, I'll ask, is there any last opportunity for questions? So we are ready to bring this up here for discussion and a motion from commissioners.
You know, I wanted to explain to those in the room who may not understand the process, the reason why we have this finance class at 300 level today, which is, I think it might even be a 400 level at college, is because all of these districts have property owners in them which get to vote on these plans in November. So they have to come today or the next planning meeting so they can get their ballots ready. And that's why we feel like we're getting soaked in math, because it's a lot of numbers. I move approval of the Monument Ridge Metropolitan Districts 1 through 3 Special District Service Plan.
Second.
Okay, that's been moved and seconded. One last opportunity for any comments. And we'll call the roll. Commissioner Weissong.
Aye.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams.
Aye.
And the chair votes aye. That passes 5-0. Thank you very much. And we will move to item 12.
Item number 12 is a special district service plan, Haven Valley Metropolitan District, a request from Spencer Fain LLP for approval of a Colorado Revised Statutes Title 32 Special District Service Plan for Haven Valley Metropolitan District. The 13-acre area included within the request is zoned PUD, Planned Unit Development, and is south of Bradley Road and southeast of the intersection of Main Street and Cable Lane. The service plan includes the following: a maximum debt authorization of $9 million, a debt service mill levy of 50 mills for residential, and an operations and maintenance mill levy of 10 mills, and 0 mills for special use, for a total maximum combined mill levy of 60 mills. The item was heard on the regular agenda at the July 17, 2025 Planning Commission meeting and was recommended for approval with a vote of 5-0. There is no public opposition to the request. Multiple parcel numbers: Commissioner District Number 4, file ID 25001, Carrie Parsons, Principal Planner, Planning and Community Development.
Good morning, Carrie Parsons for the record. Thank you, Ms. Allred, for reading that into the record. Haven Valley Metropolitan District, and this one is also going to be a little bit unique. If there's anybody watching and you want to participate, please email the email on your screen and we'll get you in the queue. This is a request, as mentioned, for a 13-acre project zoned planned unit development. So the zoning has been implemented. The preliminary plan is approved. And I believe the final plat is, I think it has almost been, has it been recorded? It has been recorded. Now it has been recorded. So there are lots on the ground, but it is my understanding that no lots have been sold. They are all owned by the applicant that is here in the audience. This one is unique. The district does anticipate imposing and collecting facility fees for $350 per lot at the time of plat and per lot at the time of building permit. So the county will not be collecting these facility fees. The county is not aware of who and how these facility fees will be collected. However, in reviewing the application. I caught that in the service plan, so I asked them to make it very clear in the service plan under the executive summary on page 2 that these fees are proposed and when they will be collected. The developer or the applicant can speak further to those fees.
Just
Mr. Williams?
my only statement on that is that we want that definitely disclosed to the homeowner at the time of purchase so that they understand. Thanks.
Criteria for the record on the screen and has been passed out. Again, statutory purposes for the district. Same situation here where we have a centralized water provider and wastewater provider in the area that will be owning and maintaining the water and wastewater infrastructure upon completion by the district. I already mentioned that the zoning was implemented and now the final plat has now been approved and now recorded. Picture of the zoning, and this property does include a detention pond to the west of the zoning line. That's an existing pond south of the solar garden, south of the church. And so this district will be designing, constructing, operating, and maintaining that offsite pound, which does improve the overall detention and drainage in the area. Commissioner Applegate, this is your district, and I'm not sure, but we had in the past received comments from these folks down here south of this project. And so as discussed at the time of the preliminary plan, PUD, and final plat, it is anticipated that this will actually improve the overall detention in the facility because it will be collected before it's discharged, and the district will have that power. There is also some minor public improvements to Cable Lane, which is a county-owned public right-of-way. The remainder of the public infrastructure will be the private roads within the development that the district will own and maintain. Current mill levies on the property, 98 mills. If implemented at full, the district mill levy would be about 158.2 mills. Again, master plan identifies that development should pay for its own way, the district being that one of the financing avenues. Summary of the application. I mentioned already that security, water, and sanitation is going to provide the water, wastewater infrastructure. That district does not do any other services. They don't have the facilities or the means and ways to provide public road or private road and drainage infrastructure. There is a letter in the packet online in EDARP file from Fountain Mutual Metropolitan District and the Glen Metropolitan Districts stating that they don't have the capability of providing services to this new development. And the debt authorization is about $9 million. Currently, the estimated cost of improvements is about $8.1 million. So just a little bit of cushion built in case there's some inflation for the developer before the completion of the project. And the financial plan does conclude that they have the ability to pay off their bonds within, again, that 40-year term. That 40-year term has been written into the service plan to comply with the new state law. Are there any questions from staff? Or for staff, sorry.
Okay, looks like
thank
done
you.
at this time. We are ready for the applicant. Oh, sorry, we have a quick question. Go ahead.
You
Mr. Applegate.
referred to Cable Lane as you said a right of way. Oh, that was that's a dirt road though, because there's like commercial and residential businesses off of that, and access to those roads are off of that road.
I'm going to open my slide back
So
up
if you
if
go
I
Cable
may.
Lane to the north, there's a church over there. That's
Church-
a dirt road that leads to their property.
So
You
this,
said right of way. You made it sound like it was just something the service trucks would go through. But there's residential traffic is carried on that road, correct?
correct. So I'm
That's what I
sorry,
thought,
let me
yeah, okay,
clarify.
okay.
So when I say right of way, means of travel, the county right of way, and then there's road within the
Okay.
right of way. I apologize, sir. I wasn't very clear. It's my fault.
No, you're good. No worries. I just wanted to get clarity on that. I was like, wait a second. I was like, that carries residential traffic. So you're good. Thank you.
Yes, and it will continue to carry residential traffic. It's just this development needs to do some improvements to accommodate the traffic that they're generating. Okay, sorry about that. And I hope I didn't just hit delete. Apologize if I did. I'll pull it back up when I.
Good afternoon. My name is Laura Heinrich. I'm an attorney at Spencer Fane. I'm here on behalf of the applicant Challenger Communities. We are here today that you request the service plan. We are here to request that you approve the service plan for Haven Valley Metropolitan District. The purpose of a metropolitan district is to finance, construct, maintain, and operate public improvements that are needed to serve property. And the purpose of the service plan is to serve as the governing document for the district, and it sets forth the powers, limitations, and restrictions of the district. The district will be located south of Bradley Road and southeast of Cable Lane. I'm sorry, the intersection of Main Street and Cable Lane. The district will consist of approximately 13 acres. You can see the boundary map on this screen. It is within the service areas of Security Water District, Security Sanitation District, and Security Fire Protection District, which will provide services to the district. The development will consist of 98 single-family units that are anticipated to be fully built out in 2028. The purpose of the district during the development phase is to finance and construct public improvements using public financing tools. And then upon build out, the district will still exist in order to operate and maintain district streets, sidewalks, one detention pond, monuments, a trail, and open space. It is also anticipated that the district will provide trash, snow removal, and covenant enforcement and design review services. It's estimated that the public improvements will cost approximately $8.1 million. The public improvements will consist of roadway improvements, water improvements, sanitary sewer improvements, drainage improvements, including that detention pond that Ms. Parsons mentioned, and park and recreation improvements. This slide shows the water improvements and the sanitary sewer improvements. And you can see that the detention pond is located on the west side of the district. Here you see the roadway improvements and the landscape and park improvements. I next want to talk about how the district will pay for the public improvements and ongoing services. The district will issue debt, but it will be required to issue debt within the parameters of the service plan that you are looking at today. The maximum amount of debt that the district will be able to issue is $9 million. And like I said earlier, the cost of public improvements is estimated to be approximately $8.1 million. The maximum debt maturity term set forth in the service plan is 30 years, which does not include refundings. But we did include the maximum debt mill levy imposition term that you have already heard about today, with the 40 years, which states that the district shall not impose debt service mill levy for a single property which exceeds 40 years after the initial imposition, unless a majority resident board votes in favor of a longer term. The maximum debt mill levy set forth in the service plan is 50 mills. The maximum operations and maintenance mill levy is 10 mills. And then the service plan sets forth a maximum combined mill levy of 60 mills. This slide shows the district's impact on a $450,000 residence, utilizing 60 mills, which is the maximum mill levy allowed under the service plan. We calculated that an owner of a $450,000 residence would be required to pay $1,836 in taxes per year, and that amounts to $153 of taxes owed each month. This development summary projection is taken from the financial plan that's included in the service plan. And as you can see, it shows the 98 units that will be constructed by 2028 that will have a total statutory actual value of approximately $44 million. This slide shows the bond payoff and resident impact. The district anticipates issuing bonds in 2026 and then refinancing those bonds in 2036. The bonds will all be tax exempt. I don't want to go into too much detail because I know you have all that information in front of you on the slide, but as you can see, this does meet the threshold of the maximum imposition period of 40 years. D.A. Davidson prepared the chart that you see on the left side, which shows that the projected revenues generated from the development of the district are sufficient to retire all anticipated debt to be issued by the district. The district will be subject to transparency and disclosure requirements. The district will file an annual report with the county. The district will hold annual town hall meetings for residents. The district will establish and maintain a website. The district will send out call for nominations once there's people who are living in the community so that they are aware when the elections are held. So if they are interested in being on the board, they can go ahead and submit a self-nomination form and run for office. The district will also provides transparency notices to eligible electors each year before January 15th. And then I also want to point out that there are disclosure requirements that builders must provide written disclosure about the district, including expected future property taxes to potential home buyers. And now, pursuant to House Bill 25-1219, all sellers of residential property are also required to provide such notice. So they will be aware of the district. This slide sets forth the conditions for approval that I know you are well aware of after going through all these other districts today. We do believe that the Haven Valley Metropolitan District meets all of these criteria shown on this slide. There is sufficient existing and projected need for organized service in the area. This project will require a significant amount of infrastructure, and there's not another governmental entity that's willing or able to take this on. The existing service in the area to be served is inadequate for present and projected needs. The proposed district is capable of providing economical and sufficient service to the area within its boundaries. The district will ensure that the public improvements are constructed within a reasonable period of time for the benefit of the community, and the district's involvement will lower the costs of the public improvements. The area to be included in the proposed district has or will have the financial ability to discharge the proposed indebtedness on a reasonable basis, and we did show that on that previous slide that I went through with you today. So we respectfully request that you approve the service plan for Haven Valley Metropolitan District. We are available for any questions that you have.
Okay, are there questions from commissioners on this one? All right, you have the benefit of having done a lot of these today. Okay, thank you very much for your presentation. I'll just make sure we don't have any additional questions for staff next. Okay, thank you so much, and we will go ahead and move to the public input portion of the hearing. Is there anyone here today who'd like to speak in support of this application? Okay, I see no one in the room and no one online. Do we have anyone here who would like to speak in opposition to this application today? No one in the room and no one online. Nothing to rebut unless there's anything that you've realized you'd like to add. Thank you. Okay, last chance for any additional questions before we close this public hearing and move to discussion and a motion from commissioners. Who'd like to kick us off? Commissioner Applegate, it is in your district. If you'd like, we'll give you the opportunity.
Should I be making comments, or are you
You can do
or
either.
are we just ready for a motion?
You can do either you'd like, sir.
Okay. Alrighty. Thank you for all your hard work on this. Let's put it that way. So appreciate it. And with that, I'd like to move to approve the service plan for Haven Valley Metropolitan District.
Second.
Okay, that's been moved and seconded. Any comments? Ready for that vote? Commissioner Wysong,
Aye.
Commissioner Nelson,
Aye.
Commissioner Applegate,
Aye.
Vice Chair Williams,
Aye.
and the chair votes aye. That passes 5-0. Thank you. Okay, before we move on in the agenda, it is just after 12 o'clock, and we are going to take a recess until 1 o'clock for lunch. I think the applicant may have already been made aware of the next item. So we're going to go ahead and do that at this time. We will reconvene at 1 o'clock. We are in recess. I'll call this meeting back to order. Good afternoon. We are moving on to item 13.
Item number 13 is a sketch plan, Flying Horse East Phase 1, a request by Flying Horse Land Company LLC for approval of 1,821.3 acre sketch plan consisting of approximately 818 acres of residential uses, 31.2 acres of commercial uses, 89.9 acres of institutional uses, 521.1 acres of land designated as mixed use, 47.7 acres of right-of-way, 30.6 acres of open space parks, 96.6 acres of land dedicated to stormwater detention, and 186.1 acres of land set aside for preservation of the natural floodway that flows through the property. At full build-out, the maximum development potential contemplated within the sketch plan area consists of 4,973 dwelling units, a maximum potential gross density of 6 dwelling units per acre. The property is zoned RR5 residential rural, CR commercial regional, CC commercial community, RS 5000 residential suburban, and I2 limited industrial, and is located at 16661 Highway 94, Colorado Springs, Colorado 80930. The item was heard on the regular agenda at the June 19th, 2025 Planning Commission meeting, and the motion for recommendation of approval failed with a vote of 3-5, resulting in a recommendation for denial. Parcel numbers 4400000438, 360, and 374. Commissioner District Number 4, file SKP 24002, Ryan Hauser, Principal Planner, Planning and Community Development.
Okay. Good afternoon. Again, for the record, my name is Ryan Hauser. I'm the planner with El Paso County on this project. I'm with Department of Public Works for engineering. We have Brett Diltz. To those who may be watching remotely, if you have not yet provided a name and reliable phone number and wish to speak on this item, please email that information to pcdhearings@elpasoco.com. Again, we've kind of been through this a few times today, but just to reiterate on the hearing procedure, we'll have the staff presentation, applicant presentation, public comment, applicant rebuttal, questions for staff, and then a final decision to approve or deny the project. So the request before you is a sketch plan by Flying Horse Land Company for about 1,800 acres. I won't repeat everything that was already relayed into the record. There is a more robust, detailed analysis of the densities and the specific land uses in the staff packet as well. This is more of just a summary on this slide. But we can go back to it at any time if anyone has any questions about the actual specifics that are being proposed in the sketch plan. The current zoning on the property was established in, I believe, the mid to late 1980s and would need to be updated prior to any approvals of any preliminary plans or final plats. The applicant would need to come back and update the zoning to support the project. This slide just has the criteria of approval. I won't dwell on it for too long. I just want to make sure that I mention for the record and for the folks in the audience, this is the criteria that the board will be considering when they consider this application. So their decision should be based solely on whether or not the application meets the or is consistent with this criteria. This is just a picture illustrating the sketch plan. So you can see most of the residential proposed development is on the north side of the property. South side of the property, they have included as mixed use. And then further south from the subject property, you can see the extent of Schriever Space 4 space. Highway 94 on the north side. And I've got a more blown up map for context on a later slide. But this is just a good general depiction of what they're actually proposing. This green area being the floodplain that runs through the property. And the general idea being a density transition where the higher density residential is proposed closer towards the intersection of Enoch Road and Highway 94, and then it peppers down to lower density as you go further south and east. So one thing that I do want to mention while I'm on this slide too, more for the benefit of the public as well, is that a sketch plan is something similar to a concept plan. So this isn't an actual development proposal where if this plan is approved, it doesn't mean they can go and build houses. It's just a conceptual plan, and we're evaluating the feasibility of potentially being able to develop at this scale. So when we say on this slide where it says at full build out, the maximum development potential is approximately 5,000 dwelling units, that's considered as a conceptual maximum. It doesn't necessarily mean they're going to put 4,973 units. It just applies that as a maximum. If they want to go over that, they'll need to come back with a sketch plan amendment. And the same concept applies to the commercial lands and any of the other mixed use items as well. Did you have a question?
Yeah, I appreciate you pointing that out. To go a bit further and helping to explain that, can you explain the steps of what comes next if a sketch plan is approved and what has to happen to get to those final phases?
Absolutely. So if the sketch plan is approved, like I said, the applicant will need to come back and actually submit a request for zoning. So that would be when they would either do a PUD or they could do conventional zoning, depending on what their development proposal consists of. At that point, we'll usually get a concurrent preliminary plan application. So with subdivisions, it's usually a 3-step process for larger subdivisions. The first step being the conceptual sketch plan, second step being the preliminary plan, and the third step being the final plat. When we receive zoning and preliminary plan approvals, that's when we start to see more of the specifics in terms of for this phase. So say hypothetically, they submit a preliminary plan for this northwest portion of the property. They would say on this acreage, we're proposing X number of residential lots, X number of tracts. This is where our open space is going to be. And then if the preliminary plan gets approved, they would then have to come back with a final plat to actually create those lots and create those divisions of land. Does that?
Yes, exactly. That's just wanted to make sure it was clear what happens from here, because it can be a very confusing process for new folks.
Yeah, and I think the most challenging aspect of a sketch plan is trying to determine where you draw the line in terms of specifics and saying, well, this is a concept plan, but we are still looking at general use categories, so residential or commercial or mixed use or things of that nature. So when we are looking at a sketch plan, the main consideration is, are the general use categories determined to be compatible with the surrounding area? So this is the context slide that I had mentioned earlier, showing the zoning of the surrounding area and providing a little bit more context to the area. To the east of here, and this is about 2 miles from the subject property, you see this pink blob. That's the Mayberry development. Further to the west, you can see the Colorado Springs city boundary. Property is located on the south side of Highway 94, and then I believe it's about 6.5 or 7 miles south of Meadow Lake Airport, just for general context. I think this is important to identify too, because something that I did not put in the staff report or on this slide to note is that the proposed density that the sketch plan would support, the closest thing comparable would probably be Mayberry. I can't remember off the top of my head exactly what the density, the general density for Mayberry is. There are about 250 platted lots out there right now. But this, we can kind of look at conceptually in a similar manner to Mayberry, which does have an approved sketch plan, does have approved zoning for phase 1, and it does have approved final plats for the first couple of filings for Mayberry. One of the first criteria points for a sketch plan is general conformance with the El Paso County Master Plan. And that includes multiple aspects of the land use chapter, which are the place type, area of change, key area, and then any special additional components to it. So for the place type, this property is located within the suburban residential place type, which recommends pretty much all of the proposed land uses that the applicant is proposing with the sketch plan. The difference here is that the suburban residential place type only recommends residential up to 5 units per acre, and there are segments of the sketch plan that could allow them to develop up to 8 units per acre in the urban medium high density area, and then up to 14 units per acre in the high density. So it is exceeding the recommended density within the place type. And I think it's important to emphasize the word recommendation when we talk about the master plan, because the master plan is intended more as a guiding document. And when we look at general conformance with the master plan, it's not intended that every single development is going to meet every single component of the master plan. So there may be aspects that maybe it doesn't meet, but then there are other aspects that it does. So it's a little bit more than just a black and white, does it meet it or not? And I think that's very important, specifically for this project with regards to analysis of the place types and the specific development areas. Being so close to Schriever Space Force Base, this property is also located within the buffer area for the military place type, which provides a little bit more flexibility with land use proposals. It identifies residential and non-residential uses as potentially appropriate, but it doesn't specify a maximum density. So that could be where you could make the argument that it's exceeding the maximum recommended density in the suburban residential, but it could still be supported by the military place type. Something else that's important with regards to the military place type is that it does emphasize the importance of compatible use transitions and buffers adjacent to the installations. The sketch plan does not identify any specific buffers along the base boundary. However, through the process and through coordination between the applicants and the base, they have kind of changed their development proposal to incorporate what they're calling mixed use, which again would need to be more specifically identified at later stages to determine what exactly would the mixed use consist of. But they've included that area on the south side of the property specifically to limit the 24-hour component of folks right next to the base boundary. If it being more commercial or industrial focused, people aren't going to be using those properties 24 hours a day like they would be on residential property, was the logic that they've used in their proposal for that. Specifics as far as buffering and setbacks and things of that nature, we would get at later stages. Those aren't usually specifics that we would get at a sketch plan process. We would see those more with the zoning. They do a PUD, or when they do a preliminary plan, they'll need to actually identify this is where the lots are going to go and where the buffer areas and where the setbacks and all of those things are gonna pan out. The property, so moving on in the master plan, for the area of change, the property is located in the new development area of change, which emphasizes a potential transformation in character for this area, which this project, if approved, could potentially result in a transformation of character for the area, which is consistent with that area of change. And it is located in the potential areas for annexation for the key areas, although the city was sent a referral for this and did not express any interest in annexing the property at this time. Property is also located in the Schriever Air Force Base Suburban Residential Priority Development Area, which is a bit of a mouthful. On this slide, this second bullet point and then the following dash points, it's just copied and pasted from the master plan for that priority development area. I think one of the more important ones is the one that I've highlighted in bold. It says efficient use of land helps preserve open space and reduce impacts on the critical missions being performed at Schriever and adjacent rural areas. So these are also components that we'll take into consideration when we're talking about conformance with the master plan. And then at this time, unless you had any quick questions for me on the zoning or the master plan, I would like to turn it over to engineering for drainage and transportation.
Good afternoon, Brett Diltz, El Paso County Department of Public Works. This project site lies within 3 drainage basins. It is in the Livestock Company Basin, the Drennan Basin, and the Upper East Chico Basin. None of these basins have been studied, However, two of them, the Upper East Chico and the Livestock Company, are fee-paying basins. Fees for those will be due at time of final plat as this moves along. A master development drainage plan was submitted with the sketch plan application. They propose currently 15 separate stormwater detention facilities. Those will be designed in more detail with each preliminary plan and final plat that comes through. So as the project moves along, each one will be developed and determined. No grading and erosion control plan is required at sketch plan time. Those two will be submitted during preliminary plan. Any questions on drainage?
Doesn't appear that we have any questions on drainage. Thank you.
And then transportation, the project will be subject to the El Paso County Road Impact Fee Program. A master traffic impact study was submitted with this sketch plan application that indicated about 39,000 average daily trips are possible with this development. Upon development build out, signalization of State Highway 94 and Slocum Road and Drake Drive are anticipated, as long as intersections for Enoch Road and proposed site access. There are 2 points of site access. As the project moves along, these locations should be monitored with each plat application that comes along so we can determine if signal warrants, when and if they are met. Also, per the master traffic impact study, it is recommended that both State Highway 94 and Enoch Road are improved to 4 lanes by year 2030 from currently 2 lanes.
We have a question from Commissioner Weisong.
Thank you, Madam Chair. If they're recommending that we have 4 lanes each way in 5 years, is that even on the plan?
4 lanes, that'd be 2 lanes each direction.
Right, total of 4.
Yeah.
Is that even on any plan?
It is on the MTCP, I believe, for Enoch Road.
Okay, because I remember reading somewhere in the packets of information that BPACG or DOT doesn't have anything.
The CDOT I can't speak to for 94.
Okay. So we could be putting a lot of additional traffic, and we have no plans to expand. Well, we may have plans, we have no funding to do anything with the highway is what I'm
Or as
hearing.
federal or state and county funding, correct?
Okay, thank you.
Can I state, did you say, does CDOT have anything for Highway 94 out there? I don't think they do.
I don't know that.
Okay.
They had comments on this project, but I don't know what their plans are for Colorado 94.
And Highway 94, to my knowledge, out there is not on our Pikes Peak Rural Transportation Authority. I don't think that
Again, that
made
being
a
a
list.
CDOT owned right of way, I don't think they're part of that.
Well, sometimes we sneak in 1 or 2 of those that might be owned by them, like Powers North Boulevard. But okay, just wondering. Thank you.
Commissioner Nelson.
Will you be speaking to the comments that CDOT did provide at
No, I
some
will
point?
not be.
Where would we gather that information?
So those are in the project file. You can see those and review those.
Can you give me a page number, or
I'm sorry?
can you tell me a page number?
I've got it's an entire document of CDOT comments. This,
Oh, in the E EDART file. I thought you were
yeah,
talking
I don't know if
about
it was in the staff
packet.
report, but it's part of the EDART project file.
Okay.
I think if you are looking for those, we could probably talk to staff about getting copies.
Daniel Torres with the Department of Public Works. As Brett mentioned, CDOT with each of these applications is an outside agency reviewer, and they provide comments, which we do look at during the process. As this moves along, should it get approved, CDOT will continue to have comments, and it's anticipated that they would require access permits with that, where they would stipulate certain requirements, possible improvements to Highway 94 as well. That answer your question, Commissioner?
Yeah, thank you. I mean, I guess just thinking big picture, they cover the whole state. They know there's a lot of growth happening. So I imagine they have to know that part of what they need to be anticipating is growth across the whole state. So I just would be curious if they had any specifics to this situation that would be good for us to be aware of.
Yeah, and they do, like I said, they're outside agencies, and we do meet with them monthly. And so projects like this are brought up where we discuss those things.
Great, thank you.
You're welcome.
Any other transportation-related questions?
I don't see any at this time. Thank you.
So wrapping up the staff presentation, following is a brief summary of the Planning Commission hearing. So the item was heard on the June 19th Planning Commission meeting with a motion for recommendation of approval failed with a vote of 3 to 5, resulting in a recommendation from the Planning Commission for denial. Staff and the applicant provided testimony. Schriever Space Force Base also spoke as a neutral party to express some general concerns. And I believe that they're also present today, and they'll probably be wishing to speak as well. The motion for approval failed based on the discussions, including the concerns regarding the buffering along the Schriever property boundary, compatibility with the base in particular, and not really having too much specificity on the mixed use designation were the reasons that the planning commissioners or the members of the planning commission had identified as their reasons for voting to deny. In result of the Planning Commission hearing, staff and the developer and Schriever have had a few meetings and a few discussions, and we've come up with a notation that we're proposing to add with this project should this application be approved. It's notation 3 on the slide here, and it basically summarizes a land exchange agreement that was entered into between the Air Force, United States of America, Department of the Air Force, and the Colorado State Board of Land back in 1994. It does provide some additional buffering and screening requirements and use requirements. So we've included this as a notation for informational purposes that the developer will be required to continue to adhere to the requirements of that agreement. And that was something that the base and the developer were both agreeable to us including as a recommended notation. So for the hearings, when we held the Planning Commission hearing, we didn't have a date set for the Board of Commissioners hearing, so we actually sent out 2 notices and we posted the property twice, once for each hearing. We didn't actually receive any correspondence, any letters to my knowledge from citizens wishing to speak, but it is my understanding that there are a few folks in the audience that do wish to speak on this item. So then at this time, that would conclude the staff presentation. So I'll turn it over to the applicants. Maybe not.
Good afternoon, Commissioners. Megan Harrington, Planning Director. The CDOT letter is 3 or 4 pages long, so instead of pulling it up on the screen here, I'll step out and I'll get copies and provide those all to you so that you have access to those comments. And then after you've had a chance to review that, if you've got questions, we can have engineering come back up.
Great, thank you. Okay, with that, if we are finished with the staff presentation, we will invite the applicant to come up for their presentation.
Good morning, County Commissioners, or afternoon, I should say, past the morning. My name is Blaine Perkins. I'm the Planning and Landscape Architecture Group Lead for HR Green here in town. I'm here on behalf of Flying Horse Development, LLC. We do have owner representatives from Flying Horse Development with us as well, Adam Doyle, Drew Balsick, and Doug Stimple with Classic Homes. I did just want to speak real quickly too. I know there were already some traffic related comments. Mike Rocha, who is our traffic consultant on the project, is also here with us today. And I believe when his time comes in the presentation, he'll be able to provide a little bit more clarity to the questions you had during staff's presentation. So we are here before you today seeking approval for a sketch plan application for the proposed 1,800 acres, which we are now calling Flying Horse East Phase 1. To the left is a simplified version of the land use summary that you will see later in the slide deck for the sketch plan application that we have presented before the county today. What I would like to draw a little bit of attention to, again, and Ryan touched on a little bit in his presentation, is the existing zoning already on site. During our planning commission meeting, we did get some questions from a few of the commissioners, which Ryan was then able to find some information on when when previous applications actually rezoned the property. What we were able to determine was that was done back in 1994. Since then, as we know today, it's still agricultural farmland, so no action was taken thereafter. But the reason I do want to bring that up is as we get later in the slide deck and start talking about the land use exchange agreement between the owners of the property today and what's been agreed to upon with the base, that was done in 1990. And so I do want to just set the stage. That was one of the first times that the base had something to react to and realized it was important to start putting parameters and fail-safes in place for surrounding parcels of their military base installations. It was called into question during Planning Commission on that agreement is old. Yes, it is, but that was just because that application first rezone was also very old. So if that would have happened at a later date, then the agreement would have been a lot fresher and new. Chair, I'm actually glad you brought up some specifics earlier on the project timeline, because this is one of my first times speaking before this board with some new seats and new folks sitting up there. I did felt it was important to just put together a quick flow chart of what this would look like in terms of a project timeline. Ryan did cover the next steps, as you can kind of see there to the right in the depiction of what would be taking place thereafter. What I'd like to really focus in on today, because it's been a discussion point not only with ourselves in the base, but nearby residents during our neighborhood meeting, is the timing of all these different applications. As you can see, we made our initial submittal of the sketch plan on December 31st of last year. We were before the Planning Commission in June, and we're here before you all today in August. So in about 8 months, we were able to get through, that was roughly 3 submittals. In each of those submittals, we did get comments and feedback from CDOT, to which we then revised our traffic stuff in, as well as other review agency comments from the county. With that being an 8-month time period, what you could typically expect as we get into PUD preliminary plans, and specifically the first ones we would do, that timeline would get stretched much longer, because we have a lot of different things that we have to nail down, get into the detail on, figure out improvement plans so that we can set ourselves up for success. Once we get to a subdivision final plat application, we have enough information to provide construction level drawings, which would ultimately then lead into and be the basis of install and bidding documents that we would receive before construction commences. I think we're all well aware where the property is today, but I still just want to highlight a couple of different things on this graphic, just blown out just a little bit more than some of the other graphics, specifically with the phase 1 area. As you can see, it highlighted in the black line is actually the full holdings of Flying Horse Land Company that they purchased the property in 2019. We're looking at roughly 4,600 acres plus or minus of the whole property in its entirety. Here before you today, we're just presenting the sketch plan on phase 1, which is roughly 1,800. But what I would like to just draw attention to on this is, as we continue to work with and alongside the base and figure out what is acceptable and how we can get this done that's in a smart growth way, I do want to just highlight that as opposed to dealing with numerous other landowners in the future, because this isn't going to go away, on 2 sides of the base, they would be dealing with the same folks that they're dealing with today. And I would like to think that that would help throughout our coordination efforts that have already taken place, the building blocks that we already have, that could just streamline things in the future and make things easier as ever dynamics changing. As we start to dive into the master plan to look at conformance with what we have proposed on this application today, I did just want to start in the place types. As Ryan Hauser did allude to, we do have 2 different place types. This is one of 2 areas in unincorporated El Paso County where we're subject to adhering to 2 different ones. A typical process, so you'd just be stuck with one specific place type. As well as Planning Commission, there was some attention drawn to the density being over that 5-acre dwelling units to the acre threshold that is specified within the suburban place type. But I did just want to shed a little bit of light on that, and the reason that that could be expected is because we also have the military place type. And as you can notate on this one, there's single family detached as a primary land use. So that should be what is shown the most, and then everything listed in supporting should just be supplementary or complementary to that one. As we get to the next slide, and this is specifically for the military place types and their primary and supporting land uses, we have multifamily introduced in this one as opposed to it being supporting in suburban. I wanted to bring that up because that leads me to expect that, yes, most likely we will end up, and we have ended up over what the suburban place type is capped at 5 dwelling units to the acre, because that's where we're trying to find a nice compromise between single family detached in the suburban and multifamily being in this one, and making sure each gets its attention. A number of other uses are military operations. I did just want to highlight that, especially with light industrial and office, and set that up for some of our previous or later discussions when we start looking at the sketch plan specifically. The next part of the master plan we did look at and wanted to reference within this project, and as Mr. Hauser had stated, it is considered a new development in the areas of change map. Specifically, I won't read off to the left what we've kind of written, but I did just want to draw attention to the fact that this is new development and it's not categorized as transitional or undeveloped minimal change. So when this was rewritten, it was understood that even though there's other areas in town that are closer to bases, we can expect some level of development on that base, which then spurred on the need to develop that military place type and make sure we are doing things in conjunction with the base and not doing anything that would impose or prevent them critical missions that are currently happening. Following the area change maps, I did again just want to compound that we all are also in the priority development areas. Mr. Hauser did identify in bold, which I appreciate that second one. I also have that same list of different items from the priority development area, which we're in Schriever. I do just want to kind of bookmark that efficient use of land helps preserve open space and reduce impacts to the base for later discussion in terms of some of the specific land uses we have identified near and around the base installation on the southern border. Final chapter I did just want to bring in, and this may not be a very common thing to bring in with a predominantly residential application for a sketch plan, but we still do have other components as economic development within the El Paso County Master Plan, and specifically mixed use. By nature, this whole plan is mixed use. We have a number of different land uses identified in one area, but then I also do want to just draw attention down to the bottom half, or bottom quarter, I should say, of the sketch plan with the specific mixed use land use designation. As you all are aware today, we are working through land development code updates with El Paso County Planning Department and other key stakeholders in town to get the land development code updated. One of the considerations with that land development code update is introducing other zone districts, flex zone districts, to give some flexibility not only for developers, but for different market trends that are happening. A typical process with a sketch plan is this could be amended and amended and amended over and over again after we get past this process, depending on those changes. Our hope is trying to be forward thinking in this application and set up a portion of it to be in line with what the future land development code will be at the time. So when the time comes to do a PUD or a preliminary plan, we already have that and hopefully preventing one less change to this sketch plan. Right before our June 19th Planning Commission date, we did hold a voluntary neighborhood meeting. Roughly 30 plus, based off our sign-in sheet, including Schriever Base Force personnel, as well as El Paso County planning staff showed up. We were out there roughly on site for 6 to 8, a little over 2 hours, speaking with different groups of individuals one-on-one and addressing their concerns and questions. I did just want to stipulate on this side, to date and to our team's knowledge, we have not received one letter of opposition from any of the adjoining landowners or neighbors with what we have proposed. As we get into the sketch plan, here's just a bigger image, and then off to the left, as you can see, here is the full land use summary that I simplified earlier in the slide deck, as well as a list of goals and objectives within the El Paso County Master Plan that I feel like we are accomplishing. Real quickly, from a high level, just from a land use transitional point, what we did do, to Mr. Hauser's point earlier in the presentation, is start with suburban low density adjacent to the Rolling Hills Ranch Estate subdivision to our east, which is RR5 5-acre lots and currently has residents in place. Start there with our lowest intense residential use, and then bleed that up into the South Enoch Highway 94 intersection, where we start to see land use intensifies. The second thing I'd like to draw attention to, and going back to that suburban place type and making sure we're conforming with it in the El Paso County Master Plan, is the suburban medium density, which is purposely capped from a 3 to 4.9 dwelling unit per acre range. It's the predominant land use of the residentials within this. We didn't feel like having other supporting land uses dominating that one would show conformance with that place type. So we really wanted to make sure that that was the biggest one put on here. Lastly, towards the bottom, again, that is that mixed use section that we have identified. There's been a lot of questions. As much as there is uncertainty about what could be allowed there, there have been discussions with Schriever Base Sports personnel, and they had even mentioned it at Planning Commission about taking a little bit of time on their end to figure out what is acceptable and appropriate around their base. Our hope is, at least from where we sit, that the open-endedness and the flexibility within that allows us to do that when they do have that information readily available, and we can come back to the table and sit down with them rather than trying to get a crystal ball and fill out what we should be doing in that area, and then again coming back and changing the sketch plan for another time. I won't read all the goals listed on the left side, but I do just want to highlight a handful of them, and more specifically the two at the bottom: supporting compatible land uses within and close proximity to the base. We're not proposing any sort of land use outside of either place type within the Melcastle Master Plan. So I feel like we are supporting compatible land uses in and around that base installation. And second, ensuring coordinated planning efforts for transportation impacts and access. I want to build upon that one a little bit more and say coordination in general. We're not just going to limit ourselves to talking with the base specifically about traffic impacts and what those may happen at a later date. Every part of this project, they will continue to be a referral agency. They will still have a seat at the table, and we will be working with them to make sure that this is done the right way and not prevent anything that's happening at that base. As Mr. Hauser notated, following the Planning Commission meeting, we did sit back down with Schriever Spaceport personnel for an in-person meeting. Some discussions were had on what we could do following that meeting to make this more digestible for their end or figure out different changes that needed to be made. As you can see, nothing has changed from the sketch plan, but one change that was made is this notation of approval. And the specific element of this I do want to highlight is that notation of approval was a recommendation on our side to the base. And what we're trying to accomplish with that is, even though that the land exchange use agreement that we'll get to on the next slide is a part of the title work, and we're required as a landowner regardless to adhere to it, we understand that having a bipartisan party such as El Paso County Planning Department to be a go-between with us and the base would help ease the tension and also provide a facilitator that if further discussions need to happen. So we have no issues with this notation. It was actually our recommendation to put this as a part of the resolution before you today, so that we can continue to build that trust with the base and show them that you don't have to trust us to agree to the rules we know about. They now have a measure in place hereafter to make sure we are adhering to those rules. So here listed on the left is the 1990 exchange and easements and right-of-way. Just running through really quickly, there are 4 major items listed in that agreement on what we are subject to adhere to, including a 45-foot height restriction. The next one is the electronic device limitation. During Planning Commission, that was called into question of, well, the device limitations that are currently in that agreement today probably aren't as satisfactory as opposed to what they are today, depending on how technology has advanced. We completely agree and recognize that. But I'd like to point out the key component of that, because that's already in the agreement. If that were to change, that'll be much easier to change than introducing new items to the agreement. So there we can take a step back. We recognize that, yes, stuff did change. You guys have to tell us what changed, what is now a problem, so that we can work towards updating it. I think that would be a lot harder to do if that was just completely bypassed in the original agreement and we're trying to set up framework for that to be included now. The third item, and this is what I wanted to bookmark, again, going back to that efficient land use and the priority development area listed in El Paso County's master plan, is no more than 50,000 square feet of surface or land within a 5-acre increment can be developed on. So what does that mean? What we're looking at right there in the red area is roughly north of 500 acres of land. 75 to 78% of that cannot have a structure on it. So I would say that is a pretty good efficient land use and buffering, where I can see how it's misleading with bubbles, just so we have to close in and get land use values. But that does not mean a building is going to be right along that base or along that property line. Some additional things separate from the exchange agreement that are also a part of the title work is an alternative egress point for the base in case of emergency situations. We, again, recognize that. We know that. We have committed to the base that that will not be prohibited or impacted at all with future development. It's actually our hope that it's going to be in a better condition later on to make that egress easier if it were needed. And we, again, will remain committed to making sure that does happen and it will not be impeded upon. Additionally, the last item is just the open space.
Sorry, before you move on, can you repeat those numbers again that you were saying about the no more than X square footage?
Yeah, so with 50,000 square feet and any 5 acres, so if you were to take up all of the acreages, majority of it is not going to be able to have a structure on because of that item in the agreement. Now, it can be a parking lot, it can be other things, but it cannot be a structure protruding above surface.
And that came about through the conversations you had with Schriever Air Force Base?
That was implemented in 1990.
Okay, that's part of,
yes, ma'am. Yeah.
thank you.
Yep. The last one I did just want to draw attention to is because right now there isn't the information readily available on what's an appropriate buffer, a true buffer of green space, walkable trails, trees. What we had decided to do and elect, because using the information given to us at this time, what we've tried to do along our southern border is match what's on the other side of the fence with the Tierra Vista community that currently exists on the base today. Before I get into traffic and turn it over to Mr. Rocha to present on a couple of different items, there is just one other little component I did want to throw in there that hopes that this study can speed along with the base, and just draw attention to that within the base today, there is the subdivision that's Tierra Vista. They also have a number of different commercial uses with childcare facility, I believe an int bank, and a few number of other things. And the attention I'd like to draw to that is within their controlled environment, they can already go in and study and see what specific uses are a problem for them because they have it on their base. That's knowledge they don't have to give out to anyone. They can go figure out in Tierra Vista if that number of homes with that many garage door openers and that many cell phones is a problem, then we know it's a problem. If it's not, something over a half mile away, I would deduce is not a problem either. And so there's enough information for them to go in within the specific confines of their base to do a controlled study and understand out of those uses they already have, what's the issue and what is it? And how can we relate this back to an applicant so they can make sure that they don't do the same thing? I'll turn it over to Mike Rocha now.
Hello, good afternoon. My name is Mike Rocha. I'm with SM Rocha LLC. We're traffic engineering consultants located at 6 South Tejon Street, Suite 618 in Colorado Springs. Would like to keep my presentation brief to allow for others within the team to add on to the presentation that's before you at the moment. But I do remain available after our presentation to answer some more questions that would be traffic related. In addition to me concluding my presentation, I'll try to answer some of the questions that have come up so far regarding traffic. So as part of this sketch plan application, as you have indicated in comment, SM Rocha has prepared what we're considering to be a master traffic impact study. This is to basically kind of start identifying some key improvements with some key assumptions that were a part of our traffic study as it relates to the development. Some of those key assumptions are pertaining to the densities that was talked upon, and kind of the maximum amounts of densities, and then to start to establish some timelines for evaluation of potential roadway improvements. We've assessed our analyses based off of a 2-year or 2 different time zones, one 5 years, which is the 2030 scenario, and then long-term 2040 plus. So that was just in an effort to start kind of identifying, if you will, the line in the sand as to what improvements could potentially be required as this development started to come online overall in full development, as well as some key improvements to assist the PPACG's plan, the MPO's plans, CDOT's plans, PPRTA's plans, the county's transportation plan. So this is an area within the county that is new to development, and development per your overall comp plan is coming this way. There are, in our coordination of this master traffic study, we reviewed all of the area documents that were available. You'll also see that within the comments that have been issued from CDOT, those are very technical in nature, but we worked closely with county engineering as well as CDOT to address those comments. And so far, we've addressed all of the comments to date. The purpose of a lot of those technical comments was to start identifying roadway corridor visions. We have within one of the transportation plans, there was clearly defined the vision of Enoch Road being set aside or be looked at for a future 4-lane roadway. So that's 2 lanes in each direction with potential center turn lanes, medians, et cetera. Not a lot of information was available in terms of Highway 94, but through the referral comments that we received from the county as well as CDOT, we are basically preparing this master traffic impact study in advance of and maybe even in support of the MPO's plans to look at and CDOT's plans to start looking at these corridors a little bit further. So we're kind of giving them a kickstart of information. We've done traffic analyses, we've done traffic counts, and we've plugged in a very conservative traffic generation volume that's associated with the higher end of this sketch plan to kind of start seeing, where stuff becomes a problem. So what we've then done and what we have learned is that the MPO is looking at funding sources to kind of start studies for not only this area of the county, Highway 94 in particular, but some of the others as it relates to how it ties into Powers, how it ties into Bradley, how it ties into all of the other major roadways within the area. So we feel happy that we were able to kind of provide this initial information up front so that others can use it for future modeling. So that was kind of, as part of our master traffic study, that was the concept that we would provide for at this sketch plan level. And again, just to emphasize, the purpose of the master traffic study was to identify major or key potential transportation improvements applicable to the development and also applicable to the adjacent area. And of which we've kind of set, if you will, the bar for items that need to be evaluated a little bit further. And so those further evaluation items are, to be looked at as with later development applications as well as actual development plans come to play, such as densities, uses, et cetera. We are not expecting any traffic volumes higher than what we're presenting within our master study. Of course, if a land use comes before you that is in excess of what we have projected, county staff and county commissioners get the opportunity to review that. And so some of the key improvements generally pertain to roadway widenings, roadway classifications, and intersection geometry and control. So through our conservative traffic generation, we've been able to determine in an effort of addressing, I'll pick on CDOT's comments, for example, we've been able to determine that Highway 94, under the vision of a 4-lane roadway, so 2 lanes in each direction with maybe some sort of center median, et cetera, could accommodate not only the projected regional traffic that we have in the area, but as well as the site-generated traffic. So this was also in an attempt to comply with CDOT currently has an access management plan, which identifies somewhat the future of intersections along Highway 94 that are to be eliminated, restricted in terms of movements, and or fully supported in terms of intersection operations. So we are in full compliance with CDOT's access management plan. And then that's where we come in forward as far as identifying that, the envision of Highway 94, Enoch Road being a 4-lane roadway. We also envision that Highway 94 and Enoch, and as well as other intersections along Highway 94, are going to need some improvements. That would be at intersections, turn lanes, some widening, as well as identifying which of intersections along Highway 94 are likely candidates to be signalized to help mitigate some of the operational results that we've projected. Our study has been very specific, and this is all, as we've gone through this study, we worked closely, and I appreciate the opportunity of working very closely with county staff as well as CDOT staff to help identify and address the comments so that we can at least come through and within a certain section of our study, we've identified potential mitigation measures. So we've gone through the whole review of intersection operations today, tomorrow at 2030, and in the future at 2040 plus. And so from there, we've come up with some projected operational results. Then with coordination with county and CDOT staff, we've evaluated potential improvements in order to get intersection operations to the county's goal. The county has an operational goal of level service D or better. So we've gone through that whole exercise to identify that as later development occurs, as actual densities occur, here are some of the improvements that should be recognized and planned for as development applications come forward. The responsibility of these improvements is still to be worked out because some of them are development related, some of them are regional traffic related, and that's where we get into the MPOs and we get into CDOT plans and county's transportation plans. So there's a lot more work to be done to identify funding sources and timelines for these improvements, but at least this is a start to identify some key items that we're picking up at the moment. So that then gets into the exact list of improvements needed to support future traffic remains somewhat unknown at this time, but will be better defined later through development stages. So while our study is a master study, has not been approved to date, we're hoping that upon approval of the sketch plan today, then that triggers approval of our master traffic study. We have, again, worked very closely with county staff as well as CDOT staff to address all comments, and all comments have been, there's no further comments to address as of today. So that concludes my initial presentation. I will try to answer any more specific questions that I could that came up, say, for example, through Commissioner Wysong's question about 2030. What we did on that, if I could answer that question, so we had to pick some dates to evaluate within our traffic study to evaluate what these potential impacts or roadway mitigations would be. So the assumption that we made was based on the higher densities and the resulting traffic generation associated that's being presented to you today in the sketch plan. We just added that volume to the regional volume, the background traffic volume, if you will, and we just picked these dates and just assumed here's full development added to this scenario, and here's the results, and here's the mitigation for that. And then we looked at it at a greater distance in time where we get into growth rates of regional traffic. And again, we took the entire development, not phased, nothing, and just applied it to that long-term vision to kind of come up with some results. So hopefully to address your comment regarding adding all of this traffic in at 2030, that's not the expectation. That was just the assumption done within our model to help us identify improvements.
Commissioner Moisant?
Thank you, Madam Chair. On page 31 of your traffic study, table 7, understanding that you had to start somewhere, but if you look at 24 and 94 peak hours, you're at a level service F. State Highway 94 and Mark Shuffle, AM and PM, service level F. State Highway 94 and Curtis Road, both AM and PM, class of service level F. State Highway 94 and Enoch Road, same, AM and PM, service level F. So do you have a baseline today? I didn't see it in the traffic study, but I'm not a traffic engineer and I may have missed it.
So these were results that are being developed pre-mitigation measures. So if you go further on to the report on page 43, 42, we start to identify level of service results that are based on assumed mitigation measures. And we have met the level of service D or better on all occasions except for one, and that is the intersection of Powers Boulevard and Milton Proby.
Which is currently a D on the current table 7.
Yes.
Is there a rationale for why that didn't improve, or did you just not go that far west?
Well, so we went that far west to a point. Currently, the City of Colorado Springs, as well as CDOT, is looking at potential improvements that to that intersection, which would include the extension of Powers Boulevard. And so there's more of that extension would go all the way south to I-25. That is being studied. And so that's kind of where we stopped in terms of further mitigation to the level of service F results that we were obtaining. Again, we're looking at some really long-term projected visions or improvements. But we feel that as it relates to, all of the intersections with exception to one, we're meeting the overall county's goal in terms of our master planning and meeting the operational results of a level of service D or better. This is a particular item that I think just needs some further time to see what the city or the state does in terms of their vision of some of these regional improvements specific to that intersection.
I would like to aim a little higher. My only concern is when we say D or better, if we spend all this money and we're at a D, level D, that I think might make a lot of people unhappy that we're not really taking even a more forward view.
Yeah.
If on page 32, year 2045, that also is just based on the current intersection traffic load, correct, before mitigation?
Correct.
And that is based on the equivalent of 4,300 units. Again, taking the high number, not knowing what the final numbers are going to be. That is correct for both those numbers?
Yes.
What about phase 2? So that's going to maybe double or triple because you're going from 1,800 acres to almost 5,000 acres?
So yes to that. We do expect a growth in traffic volume. there's going to be a balance. So we have to evaluate that when we get to phase 2 of the site sketch plan applications. But there's going to be a balance over time to where we're going to see maybe a reduction in actual development that occurs within this site, as well as, the offset to what, we're going to look at the higher levels, et cetera. So again, this is more of the master traffic study level. We know that there are a lot more opportunities to review traffic operations as we get more details. But at this point in time, to answer your question, yes, there is the potential that more traffic is going to be added, but we have the application process to review that and to determine what the exact impacts are and how and if who is going to make those mitigations for those operations.
I guess kind of a final thought on this, that we're always way behind the 8 ball. Powers, perfect example. Mark Shuffle, another one. So we're spending way more than we need to add infrastructure, overpasses, what have you. It would be really interesting to look at what is the best case scenario and evaluate, that net present value cost to do what really needs to be done, instead of looking at it in such small pieces, which cause consternation to all the people that now are living there as we continue to build out, not just this one, but there's other developments that are further east. And then you have all the construction traffic. It is going to be an absolute nightmare. And that is our constituents that are going to be suffering. And I think we owe it to kind of everyone to let's really evaluate this. We may not be able to afford it, but if we plan for it, then potentially there's a whole nother opportunity that's in front of us. Thank you.
Yes, I would agree. And if I could just respond to that.
Please.
I completely understand and agree with the comment. That is the purpose of your MPOs. That is the purpose of our PPRTAs. That is the purpose of CDOT planning. While we are one piece to that, we are more of a better defined piece to that overall effort that needs to be looked at. I think that you are seeing within county commissioners' efforts, city council efforts, CDOT management efforts, they are understanding and they are hearing the concerns that are being voiced with transportation statewide. I think that this is just one piece that can be used as assistance to help solve that regional problem.
Vice Chair Williams.
I think the purpose here is that we know that the governor and perhaps our state legislature don't fund our roads the way they should. We are not going to be building the roads ahead of the development, but at the end of the day, it is also not the developer's full responsibility to develop those roads. There's a mix here. And so we did start the Pikes Peak Rural Transportation Authority to fill in those gaps. We've had requests from many other counties as to how we manage that. The PPACG has a process that they work with CDOT to manage those gaps. Unfortunately, the key piece between PPACG and CDOT is the state legislature and the governor. And as I have been on my soapbox for about 2 weeks now, they're not doing it. And that's been the big frustration, is that we as a county, we have our road impact fees. We have our developer pays the way costs through all of those districts we considered this morning with mill levies. But what we don't have is a state legislature that will also step in and say, hey, our military base Schriever is very important and we need to get that to 4 lanes sooner than later. And so we are having to do projects such as Powers North of Highway 83, which is a state-owned road because the state doesn't see the value in it. And it's very, very frustrating to me. And so I'll step off my soapbox and let you get back to your application. But there's only so much we can require a developer to do in the creation of the roads. And we have our road impact fees, which is really an innovative way to put money based upon a 35-page document that has math that is way above my level of how to put money into our roads based upon each house that goes into a development. It's unfortunate we can't go in and make the road perfect first, but we just don't do that. And I've not met a state, well, I don't know enough about it to tell you who does, in all honesty, but I know that they try.
I just want to kind of redirect the conversation a little bit here. And just as a reminder, we're getting very detailed, and it's great. I want everyone to get all their questions answered. I do want to remind us again, this is very conceptual from the top. And so all of the different things that we're talking about, that's the purpose of having a concept in the beginning. The purpose of this is to allow drill down into the future, and we want to have realistic expectations for what is required at this stage and what will be more concrete as we see potentially, if this were to pass today, future applications. And just keep that in mind, the context, and try and narrow in our scope of our criteria here today. And that looks like Commissioner Applegate has a question.
I don't know if this is narrowing in the scope, but okay, we keep talking about 94, and yes, CDOT, that's the state. I'm wondering about Enoch, though. Enoch Road is once we get start carrying traffic and we have, say, hundreds of vehicles pulling onto that street before they go onto 94. I'm assuming the developer are they willing to make those improvements to that road to get that from 2 lanes to 4 lanes? So at least to mitigate that problem on the west side.
So to answer that, if I can, just really quick, and then I'd like to conclude my presentation and turn it back over to HR Green, who has other aspects of the development that they'd like to present. So that's part of our initial steps right now, is to identify the roadway improvements that would be needed for Enoch to start accommodating some of the traffic that's associated with future growth. Whatever roadway improvements that would be a part of this particular sketch plan as it gets onto later development applications is all going to be ironed out through the developers agreements or the subdivision improvement agreements. That's to build up the responsible share of roadway improvements envisioned.
Okay, thank you.
All right, thank you.
Thank you so much. Okay, so you still have additional, and then you're going to turn it back over.
Yes.
Okay.
That is correct.
We'll try to let you finish.
Thank you.
Good afternoon, Commissioners. My name is Richie Lyon. I'm the civil engineer on this project. I'm going to go rather quickly because I believe no one had any questions for Mr. Brett Dilts on the stormwater. So I'll just go over things that maybe he didn't mention, most of which he did cover in the text here on this slide. If there's any concerns about the floodway, it is very much accounted for. We've put an additional 100-foot buffer to any development in this sketch plan. And to make it very clear, this is not a formal creek or drainage way. It does not have a name. It is a pretty mild depression, just rather wide and shallow. So it has been studied as a part of our master development drainage plan. And I think to get back to the criteria and what we're looking at today, this is a sketch plan. Engineering stuff, I'm doing it in the background, but very much it comes up as lines on a page when we're looking at today's presentation. So I just want to remind everyone that all the engineering is done in the background, but we have so many more stages to go. PUD preliminary plans, construction drawings, and we're going back and forth with the county, CDOT, all these review agencies as we go along here. So should this be approved today, and in the context of this slide with the water and wastewater spine infrastructure, that gets our foot in the door with the Metro District to have productive conversations about what future plans would truly look like from a design perspective. So that's what we're facing today. To give an overview of the plan, we'd be working with Cherokee Metro District, whom we have had meetings with in the past to discuss this. Highway 94 would have a transmission line installed. There's already a water line in there. We are predicting that we'd need a secondary transmission line for this development. Our strategy, especially on the wastewater portion, I'm going to use my mouse here to kind of point out what we're talking about, is to be respectful of Schriever Space Force Base and their property and their infrastructure. We want to stay away from it. We don't want to connect to it. We don't want to impede on it, cross it, any of that. So we're going to take the approach to the east and due south. What we're anticipating is a mixture of gravity main, lift stations, force main. Like I said, I'd be quick. So with that, does anyone have any engineering questions?
Commissioner Wison.
I can't quite read it on your map. Is that a wastewater treatment plant in the box?
It is an existing one
Okay.
that Cherokee Metro District
Thank you.
owns and maintains.
Okay, thank you.
All right, thank you.
I know there's been a lot of discussion and already questions going forward, but in summary, just want to end back. I know there's been a lot of things brought up, but at the end of the day, this is what our criteria and what we're subject to adhering to and what the decisions and being voted upon. In closing, the one last remark I did just want to say is we get that this is complex. This is not easy, but I don't want the complexity of the subject that we're talking about today prevent any action from taking place. Thank you.
Okay, I think we have one question for the applicant.
Maybe I missed it. Did you speak to fire protection? I appreciate that last slide went over the water. That was
Yeah.
the one missing piece.
So right now, we would be working with Ellicott Fire Protection.
Okay.
They are a volunteer fire agency. At this stage, we have had preliminary introduced. They are aware of the application coming in, but at this time, there's no need to prolong or have further discussions with them until we realize or figure out if this is actually moving forward or not. However, if this were to move forward, absolutely, that would be one of the bigger items, as well as Cherokee Metropolitan District, to sit down and figure out what they have to date, what they need, whether it's additional funding, another station, additional equipment, what we would need to do, because we do recognize we're bringing additional stuff back in there. And as well as the school districts, we did go ahead and locate the institutional on the sketch plan. That was in regards, if you're familiar with the Flying Horse Main subdivision on Interquest and Northgate, that was put in there. And the idea currently is that would be a charter school that would either work with the adjoining land district or separate. But we do know and feel like we could already go ahead and do that based off some prior projects that we worked on.
Okay, thank you. I just am going through this list of criteria, and that was one I don't think I had heard about yet. So thanks so much.
Okay, Commissioner Applegate.
Have you spoken with Schriever's Fire Department as well?
No, we have spoken with 3 representatives that are empowered by the base to sit down and talk with us. And so those are the only folks we have had access to during this application process to go over, but nothing fire related from their standpoint has been brought up to date.
Okay, would you seek to talk to them?
Absolutely.
Because of proximity reasons, I was going to say, if Ellicott stayed
absolutely.
on another call, they can't respond. Schriever's right there.
Absolutely.
And to be brutally honest, unless one of their buildings is literally on fire, I think they would be on top of it. So,
Yeah, absolutely.
Okay, thank you.
Okay, final call for questions of the applicant at this moment. All right, thank you so much. Okay, before we move into public input, I will ask if there are any questions for staff. I have just a couple about traffic, so maybe both of you. We'll see which one of you wants to answer it. There's some discussion around roads, and I do think it's very difficult to get down to the complete nitty-gritty at this point, and that's why we're in the middle of this process. I think similar to the process that we have here for impact fees and those types of things, we're not looking at roads. I mean, clearly we're not looking at roads and saying the way it is today is the way it'll be. We are looking for those improvements and requiring those improvements. The county, the state has similar processes, and nothing can move forward until all those things are met. However, there was some discussion about D intersections, and I know this is a bit confusing, so I want to make sure that I have it correct and also make sure that it's clear on the record for everyone. A D intersection. What is a D intersection?
So that's in regards to a level of service. A level of service is a measurement that traffic engineers use for drivers' perception of traffic conditions, like at a stop condition. A being very little delay all the way to F, where drivers feel that that is unacceptable. D is still considered satisfactory, and that is a standard that is recognized nationwide. So D or better, that's where driver's perception is considered acceptable, like waiting at a stop condition for them to do their turn movements or go through an intersection.
Okay, thank you. I believed that was the case, that was satisfactory and it was a national standard, but I wanted to make sure that I had that correct and that was understood for everyone, that it is a national standard and it is considered satisfactory. So thank you. Okay. With that, if there are no additional questions for staff, I think I was the only one, we can move to the public input portion of this hearing. And we will start with anyone who is in support of this application. I want to remind you that every speaker does have 3 minutes, and you will need to state your name for the record and sign in. So if you are here to speak in support of this application at this time, would you please come forward? Do we have anyone online? Okay, seeing none, we now have, wait, are you coming down for support? Okay, so please come on down. Please. Well, it should be there.
I found it. Thank you so much, Chair Geithner and members of this distinguished body. My name is Jonna Reeder Claymire, and I'm the President and CEO of the Colorado Springs Chamber of Commerce and Economic Development Corporation. I actually am not here to speak to endorse any specific project, but I am here to speak to the merits of development needs to support our military families and bases. Our bases anchor thousands of jobs and millions in economic impact, and they have needs from this community in addition to protecting base security. We don't have to look any further than the Space Command decision. Originally, 5 to 7 years ago, we were not chosen as the location, and the reasons that were given were a lack of quality housing at affordable prices, of having childcare and health care in and around the bases. Housing, childcare, healthcare, and amenities are constantly requested by military leadership, and that is part of the responsibility of private development near those installations. Developers, landowners, and the county, we need a stable framework that can guide decision-making. Prolonging clarity for 2 years, as was mentioned as an option in the Planning Commission, is truly not acceptable for economic development. You know, good guidance and communication on what is needed, that's what will work. We need the why. We don't have to have the why on why the bases don't need us to build certain things. We just need to know the what. And that was discussed by today's applicant. You know, protecting national security is a first priority of any developer or development in Colorado Springs and El Paso County, and this certainly would be a top priority. We want to work in concert to protect national security and meet the needs of military families. But landowners want to be partners in protecting the mission, and they have to meet with base officials per local and state requirements in planning. Clear guidance in a timely fashion protects both property rights and national security. Without that, this uncertainty can feel like a land taking and could erode trust in our community. The county is the right convener to balance defense, growth, and private property rights. And since we are at the beginning phases of this sketch plan, I think it's important that we move this process forward because there are so many needs in this community, and waiting a few years is really going to be hard for those military families that are in need of childcare and quality housing and those other items. We need open dialogue to jointly solve for these needs around our bases while we protect security of these missions, and while possibly a study, an advisory study, is conducted. The Chamber and EDC is committed to assisting in any way that this distinguished body might need us to convene those private property owners
In closing, I would say thank you for this opportunity, and your chamber and EDC is here to be helpful. Thank you so much for your time.
Do you have a question?
Yes, Jana?
So sorry, Commissioner.
That's all right. You made reference, and since you're in a great position to, I think, answer this question, that we know that military bases generate a lot of economic prosperity.
Yes, sir.
If Schriever left, what would that do to the community?
Well, if any of our military installations left, it would not be good for our community. We're blessed that there are so many and so many different missions that are occurring here, but that's why we work every day to ensure that we're providing the things around the bases that the military leadership have told us are important to not only national security, but also to keep the military families focused on mission critical versus being stressed about childcare and other things.
How many people are employed at Schriever?
You would need to ask one of the military officials.
Okay, some of the documentation we received, 7,000 people. So if 7,000 people no longer had a job and either had to move somewhere else, that would be a substantial blow to the economy of Colorado Springs and El Paso County, correct?
That would definitely be correct, sir. And we worry every day when we are told about those that are in the early stages of their career that they can't afford housing that we have here. They can't find housing that's available. We're short 16,000 slots for childcare today. And this also affects whether or not that those mission critical operations can stay here. So yes, it's not an either or, it's an and.
Okay, thank you.
Yes, sir.
Thank you. Is there anyone else who'd like to speak in support? Thank you so much. And again, please do make sure you're signed in. State your name clearly for the record, and you can begin when you're ready for your 3 minutes.
I'm actually following Jana's lead and saying I'm not here in support or in opposition. My name is Rocky Scott. Good afternoon, Chair Geithner and commissioners. I'm really here to speak as a citizen on the issue of land use decisions and community economic health, and I appreciate the opportunity to do that. I'm not here to support or oppose this specific item, as there really isn't enough data, I think, to come to a conclusion about how it would meet suggested decision criteria, which I'll discuss in a minute. Only to request that certain key criteria be applied to this and any similar future projects as part of the evaluation of a project. My passion is centered on positive community outcomes for families economically. I've been involved in economic development efforts for 16 years, luckily mostly during very good times. The community team, including the county, city, state utilities, UCCS, Pikes Peak Community College, and others, played key collaborative roles during that time in attracting over 40,000 primary jobs to this county. He is now ably led by Jana Kleymeyer, who just spoke to you, who's doing a great job, I believe, with bigger challenges than we faced, and I support her comments. I served as vice chair of the Colorado Transportation Commission. I was active for 15 years in the real estate industry, served in an engineering project management role as an officer in the U.S. Army, and in various civic leadership roles. My perspective of the current situation related to economic health and land use is that the abundance that enabled our past successes is for the most part gone. It's not likely to grow much over time, and it's important to now adopt a perspective that reflects current realities. New realities include that we no longer enjoy abundant and inexpensive housing, electric power, water, road and highway capacity, and industrial and office building sites. John just mentioned some of these, nor secured land buffers around military bases, reducing potential interference with essential military operations. All of that, all those winds were blowing in our favor back in those days, which led to that a great period of success that we have. We know that adding new capacity is difficult. It's time consuming. It's expensive. While serving on the State Transportation Commission, I learned that the unfunded cost of meeting demand for city and county and state roads and highways in El Paso County over this decade would be over $4 billion unfunded. Partial progress has been made. We see it out there with all the construction that's slowing us down, but growing congestion is still seen every day on roads and highways. The impact on all of us is that insufficient transportation capacity impacts the cost of doing business, our quality of life, and safety. Fire engines and ambulances need to get to fires quickly. The lack of current and funded future capacity is an economic competitive disadvantage, and Commissioner Williams has brought that up. All government infrastructure budgets we know are now strained. Significant relief is not expected anytime soon. All land use projects, which will need to use existing or reliably funded new capacity, will be competing with each other for that limited capacity. So what do you do with all of these choices? Which projects matter the most? Let me offer some
Sir,
context.
I just do want to remind you that your 3 minutes has expired, so if you could wrap your comments up, I would appreciate that.
Let me say, at the end of the day, in my perspective, it's all about basic employers, those that export goods and services outside of the community. We must be paying attention to their needs, and particularly their infrastructure needs, as we make our decisions. And therefore, I believe that we ought to be asking those questions very early in the process to make sure we understand what it is that they need and that we have a way to meet those needs. So if we fail to meet the needs, it's our opinion, my opinion, economic base will likely decline over time. Land use choices, I don't think most people realize, do drive community
Thank you,
wealth
sir.
outcomes. So thank you.
Thank you. Okay, is there anyone else here who'd like to speak? Please come on down.
I think I'm signed in. Okay.
Thank
Yes.
you so much.
Good afternoon, members of the board. I'm Colonel Eric Bogue, the Installation Commander at Schriever Space Force Base, and I appreciate the opportunity to address you today regarding the proposed sketch plan. I understand the importance of the economic growth and development in El Paso County, and I want to ensure that the growth remains compatible with Schriever Space Force Base's critical national security imperatives. To be clear, as the previous speakers before me, I'm neither for nor against any developer or development, and just as our 19 June meeting that we attended, we're a neutral party. To set the stage, Schriever was activated in 1985 at a rural and strategic location to deliver the space operations transfer from the state of California, much for reasons of encroachment at the time. In 1990, a half-mile easement with RR5 zoning established a buffer along the north perimeter of the base to ensure compatibility with the space missions. Today, Schriever hosts approximately 7,000, I've heard a couple different numbers, dedicated personnel that support over 20 space and cyberspace mission partners, facilitating vital command, control, and communication between critical ground terminal antennas, satellites, detection and targeting assets for the entirety of our nation and our allies. Since 1998, El Paso County's population has grown significantly, inclusive of Schriever's personnel that directly contribute approximately $1 billion annually to the local community. As the installation commander, I'm responsible for the personnel, the security, and overall mission readiness of Schriever Space Force Base. As articulated at the 19 June Planning Commission hearing, we're aware of the county's master plan and the need for housing and commercial amenities for El Paso County residents, which includes Schriever Space Force Base personnel. We want to ensure future development provides affordable housing to our junior members. That demographic and compatible with our existing critical infrastructure, national defense missions, and in line with forthcoming Space Force encroachment policy that will be coming out later this year. We value our partnership with the El Paso County and surrounding communities, recognize the importance to the well-being of our military members and families. While supporting local development, mission compatibility remains paramount. We are committed to working collaboratively to find bilateral solutions that remain consistent with the El Paso County Master Plan and Schriever Space Force Base existing easement agreements, while mitigating potential impacts to our critical operations. Based on our initial assessments conducted in accordance with the service's forthcoming encroachment policy, we've identified 4 potential risk areas. Number 1, potential obstruction to ground station look angles. 2, signal loss from electromagnetic interference. 3, increased cybersecurity vulnerabilities through our interconnection of our community and base power grids. And 4, visual surveillance risks to sensitive assets from adjacent structures and potential illicit drone operations. To assess these risks against potential deviations from the county's master plan and existing easements, we propose a collaborative approach between developers and Schriever Space Force Base that yield beneficial solutions for the board's future approval. As such, we seek the board's consideration and support of this partnering effort through the completion of a comprehensive space, operations, installation, and compatibility use zone study. There's a lot of work going on behind the scenes. We understand the need and desire for future development. We'd like to do it as a willing partner, and understanding the sketch plan today is a step forward in the right direction. Appreciate your time. Thank you.
Thank you. Well, I'll ask, are there any questions first before we move on to the next speaker? I'm assuming you're going to add something, so we're going to...
There's two more for their own 3 minutes to add to the context of the conversation.
Perfect, and then we can maybe ask questions as a whole if it makes sense for you.
Yes, ma'am.
Okay, thank you. And thank you for adhering to the rules. I do appreciate it.
Good afternoon, members of the board. My name is David Berrios. I'm the Deputy Commander at Schriever Space Force Base. Thank you, Colonel Bo, for your comments. As stated, Schriever is committed to support and development, but we must be mindful of the potential encroachment hazards and guiding our Space Force policies and imperative to sustain space effects for our military community. As a Deputy Commander, I oversee the garrison's support to Schriever Space Force Base missions. I echo Colonel Bo's call for partnership and emphasize the reality of these impacts to our operational mission capabilities. Through the partner efforts he highlighted, we can garner informed and synergistic easements and development that safeguard our critical missions and fiduciary responsibilities to our taxpayers. I want to expand on two key areas and solicit assistance from the members of this board and our private developers. We seek the county's support on existing municipality ordinance to include height restrictions of structures that could obstruct Schriever's ground system look angle. The SOICO study will inform acceptable height restrictions to ensure critical communication capabilities remain. We welcome the developers' collaboration with our team for local cellular providers and power companies to mitigate electromagnetic interference, minimize signal leakage, and employ shielding techniques. This will help avoid signal loss from private and public system structures and devices. Our goal is to inform responsible development around this key military installation without exposing undue risk to our vital missions. We believe the proposed solutions presented by Colonel Bogue will enable a unified effort that serves and protects the community needs. I appreciate the consideration of these matters, and I now yield my remaining time to Mr. Domeyer from Space Operations Command, our higher field command, to provide additional insight into this important mission at Schriever. Thank you.
Good afternoon, members of the board. My name is Joe Domeyer. I want to appreciate everybody's time, and in line with what Colonel Bogue and Colonel Berrios both stated, we are proposing an agnostic and neutral position. So as such, I just wanted to I'm grateful that both gentlemen highlighted the local atmospherics to the Schriever community, and I just wanted to elevate a little bit to what the national security issues are as we want to consider within developments moving forward. So thank you both for impressing the importance of the codependence of both our public and private initiatives for economic growth in this great state of Colorado, Colorado Springs, and El Paso County. Just like you, we are part and parcel of the community. Hence our passion to align the economic growth and our mission to defend the nation. For context, we are seeing increased instances of encroachment to all Space Force locations around the nation. For context, recent threats have ranged from unintentional interference that inhibits our ground-based systems to foreign investments and alleged surveillance by nefarious actors, all of which have posed recent examples around the nation in open source documents. SPOC's mission are not simply local assets, much like Schriever Space Force Base. They are vital components of our nation's defense system, providing essential capabilities at home and abroad. Our governance process drives us proactive engagement with local developers, essential around Schriever Space Force Base. We want to ensure compatible land use and easements that minimize encroachment risks, and we fully support Schriever Space Force Base's request to partner with any future developers around Schriever Space Force Base. As such, we urge the board to support Schriever Space Force Base's partnership with any developer proposing a land change around the base. Completing a SOIQ study, as mentioned by Colonel Bogue and Colonel Barrios, will help inform and move this decision in the right way before making a decision that we may not be able to come back from. It'll inform for mutually advantageous easements and plans for all future development. We have a unique and pivotal opportunity to partner with the El Paso County and its developers to garner methodic economic growth that meet emerging community demand and national defense imperatives. Thank you for your time and consideration, and I'll yield my time for any further questions from any one of us three.
I'll begin with Vice Chair Williams.
Could you state the name of that study again, the full name?
Yes, ma'am. It's Space Operations Installation Compatibility Use Zones.
Thank you.
Yes,
I
ma'am.
appreciate that.
Commissioner Nelson.
Did you make a comment saying there will be a policy coming out later this year regarding buffer zones?
Yes. So right now, Space Operations Command is working the policy memo that's going up to the Headquarters Space Force. That'll eventually go over to the Department of the Air Force and Office of Secretary of Defense for approval to take into consideration the compatibility use zones around all Space Force installations.
Do you have any sense of the timing? I mean, I know how
Not fast
military and
enough.
government work, right?
Yeah, we've actually got it through our headquarters and it's ready to go up to Space Force headquarters.
Yes, ma'am. And as of this morning, it is up at DC. So we anticipate within the next 1 to 2 months, we will have something published.
And then that will just provide guidance to property owners surrounding these bases, as an example such as this, that here are your limitations or here are the requirements that the federal government is saying we need to have buffers around bases. Is that
I
correct?
think in addition to that, it adds the requirement on the Space Force as well and the installations themselves to produce this study that we previously mentioned. Right now, Schriever is, I would say, the test bed. We're leaning forward to get this study done to be, I would say, better partners with the local developers and local community. So we have the data that supports the asks that we're specifically looking for. So we're working ahead of that while the letter goes up to become an official Space Force policy memo.
Okay, great. I think that's the thing I keep wondering that seems to be missing in my mind with this instance of, you know what the needs of your base are and the security that is needed. And I just can't imagine that that's not clearly outlined. I know there's work that looks at the futures of the defense of our country and whether it's space or ground level, and people are planning these things out of, so I'm surprised that there isn't more guidance already in place for something like this. And so I appreciate hearing that will be coming. And I imagine that once that's implemented, then developers will have to, that will update their plans and inform their plans, correct?
Correct.
Great. Thank you. Would it sort of be like an update to that 1990, whatever it was called?
Well, the 1990 document that you're referring to, I think, is the easement that was established on the north side of the installation in collaboration with local partners of what looked like at the time. Today, obviously, things have changed 35 years later, both from the requirements outside the installation and the mission sets that are inside the installation too. So while that's specific to an easement, this will be specific to the study to conduct that may help inform future developments, easements, zoning requirements, et cetera.
Okay, thank you.
I know it's a confusing topic because we are talking very generally about the future of guidance while also being in the middle of a hearing about a very specific property. So I know that there's a lot happening in this space. I want to get a bit of clarity on your statement, sir. I think what I heard you say is that you do not oppose the sketch plan itself and that this step forward could work parallel pathways with what you're talking about coming forward over the next several months based on the timeline.
Yeah, so the not opposed for or against any sketch plan, really any development, any developer. It's just the requirement remains. While we do support responsible and collaborative growth, absolutely, we have to maintain the integrity of the missions that exist today on Schriever Space Force Base.
And today you are not here to oppose and say that it is that.
So I didn't know when to stand up, if it was oppose or for or neutral, so
No, I
we jumped
understand. We
right
really
in.
just have a support and oppose, so I understand how that
Yeah.
can be confusing. I just wanted to clarify and make sure that I had heard you correctly. So additional questions, Commissioner Weisong?
Colonel, could your top four comments, first one was look angle.
Correct.
Could you explain what that means?
So if you've ever been out to Schriever Space Force Base, you've seen numerous what we call golf balls, and that is the radomes that house the different antennas that are inside those facilities and on that installation. As those antennas, some are directional and point directly where we want them to, some rotate, but each one of them will go changes in different elevations, azimuth, and look angles. That's what we call the look angles. We understand what our limitations are. We understand what we are looking at. The risk becomes when things are built outside the installation that we don't have control over that could potentially mask those look angles or limit what we need to look at from all the satellites on orbit that we conduct out there at Schriever Space Force Base. That's the risk that we want to make sure we minimize as much as possible so we do not impact the look angles of the current and potentially future radomes and golf balls out at Schriever Space Force Base.
And so that's what I understand is horizon to horizon look angle?
Correct. So some look from horizon to horizon in multiple different directions.
Okay. In your second item?
I think that was electromagnetic interference. That's correct. Yeah. So from an EMI perspective, it happens all the time. There's natural EMI, then there's adversarial EMI when they try to barrage jam or do certain things that limit the effectiveness of our RF transmissions out of those radomes. And if they interfere with those RF transmissions if there is interference in any way to those RF transmissions, it can significantly impact the effectiveness of our mission sets on that installation. So if there's a development that is put out outside the fence on the installation, of which we have very little control over, except through the methodical process that we're going through today, we run the risk of potential adversary actors or even unintentional actors outside in a home, an apartment, a business, a complex that is radiating. If you looked at some of the plans that were up there and some of the pictures of the local area, you saw clearly the outline of the Schriever Space Force Base perimeter. Inside that outline is what we call the restricted area. And inside that restricted area is very sensitive space operational equipment that is sensitive to electromagnetic interference.
Thank you. Number 3 was your cyber. How does that impact?
So there's a very real concern from a cyber perspective on what we call our weapon system infrastructure at every Space Force installation. Without the power, the heating, the cooling, the water that comes onto the installation, then our mission sets would be impacted and ineffective almost immediately. So it's imperative that our weapon system infrastructure is protected as much as possible. Protection also includes cyber defense. There are open source reports and not open source reports that indicate our adversaries are looking at how they can get into our weapon system infrastructure from a cyber perspective through our SCADA systems and other infrastructure that we have connected to our local utility partners. We have a great partnership with the local utilities. They understand this threat vector as we do as well. We see that with development in the local area around the installation, that threat and that risk only increases and will be a deliberate point that we have to address as development occurs in that area.
And one point I just wanted to emphasize, he talked well to everything. We have seen recent events with power as well, both from a nefarious attempt as well as just inadvertent power bumps that have affected critical mission assets. I'm speaking in general, but it has happened in a local area, but it has as well a concern across the world.
Thank you. And then number 4, your visual structures. So is that kind of like your look angle, or is there something more specific?
I guess you could say a look angle from a different perspective. So if there's a building, and in this scenario, built outside the installation that has an elevation that is able to look down into the restricted area, that are able to take, they could potentially gain some intelligence value in the operations that are conducted on a day-to-day basis within that restricted area. Hence the 45-foot limitation on the current easement that's in place today. That was built, as we said, it was created in 1990. 45-foot was acceptable back then. I'm sure that a SOICU study could help inform that restriction even further today. More or less, don't know. That's why we would do the study. I think the second part of that, number 4, though, that's critically important is the use of drones. This is one of the things that I have as a top priority and a top concern out at Schriever Space Force Base. With the access to Highway 94 right outside or just a little bit up the road, and we've all seen the reports from Ukraine and Russia and a semi that's driving down the road that flaps open its top and out comes a swarm of drones. There's a potential for additional risk vectors, additional threat vectors if we build and develop outside that installation, Flying Horse East. I'm sure there are mitigation actions we can put in place. We are doing things of our own from a Department of Defense perspective, because this is not unique to Schriever Space Force Base in any way, but it is a top concern and why it made the commentary today.
As far as options to negate, eliminate some of these impacts, having development that close to the fence line, does that limit what you're able to utilize to get rid of that intrusion?
In short, yes, absolutely. There are discrete limitations on the actions that we are authorized to take. And in this instance, we'll use the drone as an example. If it comes over our installation, we have the authority to neutralize the target. If it's outside our installation in any way, it restricts what we are able to do. If there is development within at a minimum, our easement area, it only increases that threat as well right now.
Okay. Based on this and all your exercises you've run, utilizing a, lack of a better term, a red team, how easy is it to infiltrate? And I'm not looking for anything specific, but
so there are numerous vulnerabilities, but there are numerous proactive measures that we can and have taken and will take should any of these different concerns that I have articulated in the brief. There are actions that we can take to mitigate those threats.
Okay.
Speaking of national security, we're going to not press them too hard, I think, to get uncomfortable, because we know how important some of that information is. But I do want to say you and I only got a chance to shake hands upstairs, and I have met one of your colleagues, but my husband is serving in the reserves today. He's at 20 years, and we landed in this community from military, so I have the highest respect for all of our military installations and also the mission that you serve. So thank you very much. However, I do have some pointed questions here.
I'm ready.
That agreement from the 90s, as you said, it's been a long time. has that attempted to be renegotiated? Because I do know that, this has been a very long process. So have you attempted, or has there been any attempt by anyone from the federal government to renegotiate that agreement?
Renegotiate the agreement with the current development or just
Yes.
throughout the decades?
Just at any point renegotiate that agreement to add additional protections that might be needed.
So there are multiple efforts at work, right? To be very direct to your question, the answer is no, because there's been no need to. As RR5, and I live within throwing distance of that fence line on the north side, and it's all grassland and sometimes cows. So there's been no real need to go back and look at and renegotiate that, even with the different mission sets. And we've lost some missions, we've gained other missions, so things have changed over the years. But until today, it has not been necessary to renegotiate.
Okay. And then the second is we're talking about this study and you're talking about equipment that's changed. And you may not be able to answer this, but the reality is that the federal government has a lot of authorities. And it seems like it's not very proactive. This entire study, this entire conversation, these things didn't happen overnight. What is the reason that the federal government has not been more proactive, in your opinion, on making these things known for property owners that are close by or local governments? Because again, I know that technology has changed a lot, but in 35 years, it certainly is incremental, kind of to Commissioner Nelson's thoughts here. I mean, there is a lot of planning that goes on. Typically, in my experience, and my husband was Intel, and so I totally get the sensitivity around all of these things, but generally, if there are high-risk security concerns, those things need to be inside of those perimeters to be protected. So has there been an attempt to bring in any of those sensitive areas inside of the perimeter, acquiring additional properties? I know we have some other areas around Fort Carson. They have their own set of drama sometimes, but has that been attempted at this point?
Yeah, so what I could say is yes, it has been. We have a program called REPI, but I can't remember exactly. Everybody's nodding their head. Good, thanks. To your point, there is a bit of frustration, right? This conversation has been going on for many, many years. And we've been in dialogue with different developers around the local area for many years. The good news is, what I can say is this study, as it has been discussed for 2.5 years now, what we have done recently is we have put money towards it. So this is no longer just talk. We're working with the Army Corps of Engineers to let this study out to industry. We're hoping to have it on contract in December so we can take a more proactive approach instead of reactive and have the data that informs these conversations. Instead of looking into the past and what we should have done or could have done, I've got a few members of my team that said if only they would have listened to me 10 years, 20 years ago when we could have bought some of this property, we wouldn't be in this situation. The reality is we're here today and we're trying to take concrete steps to help make an informed decision moving forward on all parties.
Okay, I think that's helpful. Appreciate that. Look forward to kind of the general discussions. And as I said, want to make sure we're keeping in line with, we have to meet our criteria today. So I think that informs us, and I appreciate you all being here. And it looks like Commissioner Nelson may have a question.
I was contemplating whether to ask or not. I guess I'm just thinking about, we have other installations, Buckley, for example, that have become surrounded. And, I'm trying to discern actual risk when you speak to those 4 things of look angle, electromagnetic interference. There's so many levels of frequencies that you can use. I know just barely anything about these topics, really, but enough to know that the military has a lot of smart people that can help mitigate risk. And so I'm just trying to grasp what the actual risk is for these things.
Well, and I would say your reference to Buckley and Fort Carson, and other military installations across the country. These aren't unique concerns. These are just maybe elevated concerns because of the development right outside the installation, right? Every installation is tracking this. Department of the Air Force Defense is tracking every concern we mentioned. But it is a reality, what we call base encroachment, right? And hopefully we do responsible development in collaboration with our partners in our local community. The fact is, the reality is, every member of Schriever Space Force Base wants development, right? They want that. They want to be able to drive off base someday and maybe go to a subway or whatever. Not endorsing anybody, or be able to have affordable housing that's closer to the installation, right? We've got a lot of junior airmen, guardians, wage grade employees that would love to be a little bit closer, love to be in a home that is supportive to them and supportive to their professional development, their growth as an individual. So this is not unique. It is, but more to your question, I think the study will help address and provide the data that then really gets down to what are the risk actions and risk mitigation steps we can take to fully capture what our current capabilities are inside the fence line and what the developer is proposing to build outside the fence line.
When did you, you said Schriever has interacted with developers for years, and so these conversations have been coming. We're just really right now in this moment in time, something's coming to fruition, I guess. I'm struggling to understand why it wasn't a priority in the past to do a study like this. Like I said, I know there's so much work being done for ensuring the future of our country is secure when it comes to space and what happens if a satellite that's communications starts doing other things. I know there's a lot of forward thinking happening in that realm. I just am really struggling to understand why that wasn't the case here.
I would like to offer that I think that's one of the reasons why the Space Force stood up, right? So when you think of an ACUS, which is where we got the SOICUS.
Can you move a little closer to the mic? Thank you.
Yeah, so the Air Force bases have had the framework to protect our mission sets for years, right? And we call it in the Air Force the ACUS. When you think of the importance, how rapidly has changed our satellite and our space domain, that's where the Space Force came in, right? So in 5 years, they had to establish themselves, and now they have a more dedicated effort to look into protecting their boundaries, which before, part of a bigger mission set with all the competing priorities, it just wasn't an area of focus. That's what I think. And if we look at the different things that we've done, to include that the boss is now the commander at Schriever, which just 70 days ago, that wasn't the case. We are just really coming together, realizing the importance of all the things and all this is that we need to do to protect our mission sets.
And one thing to add, you asked why we haven't developed something to date. There has been a significant shift in just our adversarial environment landscape to show from a benign to a contested environment. And it's changed our investment portfolio completely across the department. And so as we're looking today as well as near-term emerging requirements for these invisible threats that are on the terrestrial side that can't be talked about, but we are assessing them as things are being developed and built. But without having that, I guess, near-term threat and what our near-term weapon systems are being developed to contend with, we didn't have the information at that time to make informed decisions of should we change the easement, should we change the agreements.
Well, I'm going to make a statement and say I'm very glad President Trump is back in office. I'm really hopeful that we're going to see a great investment in our national security and glad he stood up the Space Force for those reasons. So any final questions for these gentlemen? Thank you so much.
Thank you.
Okay. So we are still on the support portion of the public input that I understand that we've had several folks who wanted to remain neutral, but that is the portion under which we still are. So if you are here in support, please do come down. If you'd like to change that and say you're neutral, I suppose that's the trend. So, but please do come forward if you would like to speak during the support portion of the public input. Okay, I see no more in the room and I see no more online. So with that, we will move to opposition. And so, I'm sorry, I'm not sure what you're. Oh, okay. So before we move to opposition, we have a request for a comfort break. So we will take a brief comfort break and return. Okay, we are returning from a brief recess. We have concluded the public input in support and some who indicated they were neutral, and we are moving on to those who are in opposition to this application. So I will invite anyone who is here to speak in opposition to this application to come down at this time.
Good afternoon, Madam Chair, fellow commissioners. Thank you for affording me this opportunity to speak on this important issue today. My name is Keith Klain. I am an Army retiree. I am a past Military Affairs Council chairman here. I have now, the last decade or so, run what is called the Defense Mission Task Force, which you may, if you've been here a while, remember from back in the BRAC days and such. We retitled it, rebranded it, if you will, last year. It's now called the Colorado Defense Alliance, or CODA. So I'd speculate that most of you hadn't considered, but when you took office, that you'd be making decisions with national security implications. But you most certainly have a subject of exactly that magnitude in front of you today. While the base at the center of our conversation happens to be Schriever, the truth is that it could be, as has been alluded to, it could be any base, any of our other 4 local bases. It could be essentially any base or any military community in the country. They are all fighting these kind of challenges. Some are leading in the means of building the right plans to protect them. Some are playing catch up, but it's happening everywhere. Our bases largely around the country are 85 to 90 years old, emanating from World War II. So development has crept up on them most everywhere. Schriever, our youngest base at about 39 years right now, is the baby in the community here as far as bases go. I'd like to touch on a couple things that were left over from the last set of questions to the Space Force's defense about why there isn't a study like this on record yet. That's really quite simple. Up until well, and still today, the Air Force still has much to do with running Space Force bases. It's still a Space Force base essentially to maintain and sustain, right? It came to our attention prior to any of these commanders arriving maybe a year and a half ago that the Air Force was going to insist that in order to take into full account Space Force equities, assets, challenges, the Space Force was going to need to do their own analysis and provide that information to the Air Force for implementation. The Space Force being a brand new service, smothered with things to do, frankly, built lean and mean right from the start. They, to their credit, went to work on that notion right out of the box. That's where the whole Soyuz concept came from. And they continue to work on it. Changes of command at various levels will sometimes cost you a little time, but it is in the hands of the folks at the Pentagon, as they said, as of today. And I would think that's encouraging. But don't believe for a minute that the Air Force rules still apply. So they're still protected. They're still concerned. There's still all of those things. What we're looking for is those specific things, or those things that are specific.
Sir, I believe you wanted to combine some time from folks that are here. So
yes. I have 4 of us total.
can I see the show of hands of those who are here to donate their time to Mr. Klein? Okay, so I see 3 additional, with yours, so we can put 9 more minutes.
So anyway, that's covered.
But before you do proceed, I do have a question for you because you've made reference to we and answering some of those questions. Sir, are you here on behalf of someone?
I represent the Colorado Defense Alliance, which is a group, we build teams of teams around certain issues. The team that deals with REPI, which they started to talk about, stands for Readiness Environmental Protection Initiative. That is that Department of Defense program where we go after trying to acquire and work in concert with willing sellers to protect the interests of the base. we are heavily involved in that
So you said
process.
Colorado Defense Alliance, and what's your role there, sir?
I'm the chairman
Thank you.
the last decade.
Thank you. Sorry, proceed.
Mhm. So I've got a letter. I think it's been distributed to. I want to read for historical context. I think it's really important. So the selection of a specific site in El Paso County for construction of the Consolidated Space Operations Center, CSOC, think Falcon back in the day, was made after extensive analysis. Site selection criteria included the need for horizon-to-horizon tracking of critical defense satellites, being able to escape potential urban encroachment like that which inhibits growth at the Satellite Control Facility in Sunnyvale, California, and the need for expansion to a new DoD space program to become operational. When this CSOC site was selected after vigorous competition with a site located within a large base in New Mexico, the CSOC area was mostly grazing land owned by the state. The governor, the congressional delegation, and the board were very supportive and helpful with respect to the acquisition of Section 28, or 26, I'm sorry, a section being 1 square mile. Unfortunately, we could not initially justify acquisition of more than one section. We were not so naive as to expect that land around the CSOC would remain unchanged, and we have discussed with you the possibility of a land exchange to acquire additional land or preferably restrictive use easements around Section 26. I am pleased to report that the old Lowry bombing range site in which you expressed interest can be made available for exchange. That did subsequently happen. We should commence work toward that end as soon as possible. I will have easements estates available for an appraiser shortly and would appreciate your nominations as possible appraisers as discussed in our last meeting. Buffer easements are not the whole story. Intense development around CSOC will not necessarily be in Colorado or the board's best interests. Military use of space is in its early stages and doubtless will expand significantly. Many new functions logically could be co-located with the CSOC Space Command Complex in or adjacent to Falcon Air Force Station. These functions, should they materialize, would represent an important economic boost to both the Colorado Springs area and the state of Colorado. Using the formula presented by Mr. Steve Schuck to the state legislature, the 25,000 plus military members, now it's about 40, presently stationed in the Colorado Springs area, create 2.5 jobs per, thereby adding at the time, 62,500 employment opportunities in the area. Now, of course, much, much more than that. The Peterson Air Force Base Complex is all they had to reference at the time. At that point, its economic impact was $393 million. Today, as of last week, at least, their briefing, it was about 8 times that amount in the Bs, right? So annually in direct support of the local economy. Future expansion of, and that was without Schriever. Future expansion of Falcon Air Force Station would probably be even more economically favorable since it would likely have a large component of federal civilian and contractor jobs, as well as a high ratio of officers are enlisted to enlisted personnel. This personnel mix would have higher pay and a higher degree of permanent residence in the Colorado Springs area than an all-military population. These functions, therefore, would produce a higher multiplier and most likely a higher demand for land in the form of a single-family homes and owner-occupied condominiums. Moreover, we confidently expect new Falcon Air Force Station functions to attract high-technology industry to both carry out Falcon Air Force Station issued contracts and simply because the intellectual climate will be favorable. All of these possible developments will create a demand for land and accordingly will increase the value of the school lands. The Colorado State Land Board is all about their schools, right? Supporting schools in Colorado. These possibilities will not come into existence if Section 21 is promptly boxed in by commercial and office buildings and dense residential development. The school fund over the long run, now the county, the citizens of Colorado Springs, will be the loser if it pursues short-term speculative profits. I'm asking you to consider investing in Falcon Air Force Station by exchanging lands for buffer zones and future expansion with us on an equitable basis. And by working with us and the El Paso County Commissioners to maintain a low density of buildings and people for at least a mile in all directions and keeping structure heights below the antenna look angles. Even greater returns are possible in the future, but only if the setting of CSOC, as we originally understood it, is largely maintained. There are 9 miles of undeveloped land between CSOC and the eastern edge of the Springs. It is not a land use planning necessity that a pocket of dense development occur immediately surrounding CSOC. It is not, I suggest, in the board's long-range interest to encourage it. A CSOC that can grow and create continuing demand for planned development will prove more profitable for the board economically and far better for the community and the state as a whole. The date of that letter, February 28, 1985. This body has been engaged on some way, shape, or form since the beginning. Since the beginning. It's the Santa Clara they talk about here was one of several locations that lost these missions that were ultimately aggregated at what we now call Schriever. They lost them due to encroachment by commercial and residential entities. And we have many other bases around the country that are similarly afflicted. So while we are pro-growth, pro-development, pro-housing, all of those things we support. And we work hard to find compromises and solutions to these problems, like the one that like the issue that's before us today. We have to have certain things. We have to have sellers that are willing to engage and sell. That's a prerequisite. The DoD programs, the funds that Congress allocates every year, which we get more than our fair share of, by the way. Your community is crushing it, frankly, on that front, are allocated only in small tranches by the time it's divided up between the services down to the community level. And once entitlements have been had, the prices are probably out of reach to be solved. The situation is probably out of reach to be solved by those standing programs. So just know that that's part and parcel of what's in front of us today. I guess I'm not in opposition on the face of it to any particular development. We tend to be more concerned about ones that are in immediate proximity to the base, certain bases maybe even more so than others. But I am opposed probably to having to make a decision today until we have more information available to us about what the Space Force thinks now that they're assessing it for the first time for their own interests. So none of the people I work with are anti-growth, anti-economic development, none of those things. They'd be horrified to hear that, as am I. I've worked as a real estate broker ever since retirement. Well, actually, since before I retired from the Army, almost 40 years. When commanders talk about their needs, I've never heard even one of them say anything of the sort, except that they're opposed, except when the proposal is to put something immediately adjacent to them, right? It's about the mission to them, mission first. And I think those were the opening remarks of our commander. We all understand for housing to be as affordable as it can be, there needs to be a robust pipeline, and that developers and builders with their significant risks and big investments are critical to that process. We've got to have them. Got to have them. Let's see, I think it's fair to say that all of us would want growth and development done more smartly, which for any senior military leader would have it well removed from his or her fence line or operations. It would also include building the appropriate road infrastructure, sorry, Harley, the appropriate road infrastructure in advance. What I picture here, and what I think the picture that should have come to mind for you is a series of, as long as a deadline or a decade of road construction on a 2-lane road that's already hazardous. So getting out in front of that is important. That's why it was mentioned. When senior leaders talk about affordable housing, they are talking just like any other employer in town who wants quality, affordable housing for his or her workforce. In this case, junior airmen and guardians and other wage grade teammates, as had been mentioned. In the case of Schriever, the closest grocery is about 19 minutes away. Half of that distance would be terrific. On or near the fence line, less terrific. Speaking of road infrastructure, I think I can go over that, pass by that, and please let me wrap up here. Are we aware that Schriever is the equivalent of a foxhole for our guardians? They fight from there. They fight from there. That is their foxhole, essentially. So read into that whatever you may about the actions that they may have to employ to defend or protect themselves and their missions and in a contested environment, and how much more difficult, if not impossible, to do that would be with neighbors or neighborhoods in close proximity. Subject to your questions, I have just one parting thought. by way of a quote from a salty old veteran who once spent many years in the field of economic development, some of it right here in this fair city. He commented that rule number one in economic development is to not put at risk that which you already have. Questions?
Commissioner Weissong.
The question about the original origin. First time seeing this letter, but you
Signed by the Assistant Secretary of the Air Force at the time. But,
Yeah.
Yep.
the State Land Board originally provided Section 26.
Correct. And they are the biggest landowner in proximity, close proximity to our bases, but they are willing sellers, and we're having great luck with them. We've closed out just to the east of Schriever. We've closed 19,000 acres for $13 million just in the last 21 months. You know, but they're not under development pressure. You know, they're not in here in front of you or any other entity looking for their entitlements and what they may need to do, what they may want to do. So we are able to get those things accomplished in a much more proficient fashion in that kind of setting.
But reading this, they were looking, again, back in 86, to do an exchange of the Lowry bombing range. So I'm assuming there was a lot more state land.
Schriever has grown once. It's already grown once, right? It was added to the year maybe 1990, I think. So it has already grown once. But, you know, if you apply that logic, where does it logically end? You know, do we want the Department of Defense owning how much, where? You know, that's why these tools were created in part because of work. I'm old enough to have been involved with it at Fort Carson in 1999 when Fort Carson was deemed to be the most buffered base in the Department of Defense. From those efforts, Congressman Heffley, whose lead staffer on it was no less than Jeff Crank at the time. That's where he and I first met each other. He reminded me of the day 27 years ago. So that's where these programs, these federal programs, this REPI program that I now describe kind of emanated from that. Out of, I think, probably a fear that every single community was going to go and try to go and do what Heffley had done for us. And they built a program.
But how much of that land around Schriever, if they were looking to exchange other state property or federal property, in this case for state property, that obviously didn't happen.
Oh, it did. No, it did happen. It did happen. Oh, yes, yes. And in fact, I got a call not long ago about an issue at Lowry, at that base. It's still used for training by the National Guard. So, and we dealt with that issue, managed to solve it. It's back on the table again, actually, for conversation on how it might be commercialized. But yes, that's how the additional land was acquired. I talked about Schriever having grown once, was a swap, essentially, with land at Lowry.
But they didn't get the required 1 mile additional.
They did not end up getting a full. No, I digress. I think they did at that time get an extra mile at the time. The Schriever you see today doesn't resemble the 1 square mile that Schriever was back in the mid 80s. What you see today is a much larger Schriever than it was originally. So that transaction did in fact happen.
Okay, thank you.
Yeah.
Okay. All right. Thank you, sir.
Yes, ma'am.
Is there anyone else here today who wishes to speak in opposition? Seeing none in the room and none online. Okay. It is time for the rebuttal portion. I see someone representing our applicant coming down. So please do introduce yourself and you may begin the rebuttal process.
Good afternoon, Madams Chair and Vice Chair and members of the Commission. My name is Doug Stemple. I'm here on behalf of the applicant. I'll be fairly brief. First, thank you for your patience and your attention through a pretty long hearing. I'd like to break it up into 3 distinct areas. 1, traffic, 2, military, and 3, sketch plan criteria. And let's start with traffic. And Commissioner Weissong, I appreciate your comments on the traffic. And one thing, just for perspective, when a traffic report suggests that something needs 4-laned by 2030, and there's no development out there today, I'd submit that that means that it's what we call background traffic, non-site generated traffic that is leading to that need. That has to be considered in the future. But what we've done is a master traffic study that has met CDOT criteria and met the county traffic engineers criteria. What essentially the applicant is asking you to do is to allow them to spend more money to come back to you to prove that you should vote yes for a preliminary plan. And what will transpire in that is any number of things. We have tools. We have the El Paso County Traffic Impact Fee. We have PPRTA. We have, I couldn't agree more with the vice chair's comments about our state legislature and our governor not prioritizing certain things, and I won't digress on that. But I want to give you a perspective on something, and your county administrator was involved in this. We had a county, Town of Monument, Tri-View Road, and CDOT was involved, and it's the intersection of County Highway 105, Jackson Creek Parkway. And we wanted to develop 70 acres along Jackson Creek Parkway, the last 70 acres that catches that intersection. Traffic study was done. It said the county should pay something. It said the Town of Monument should contribute something. It said Tri-View should contribute something. And it said Classic should contribute something. Our share was 18%. No one else had the money besides the county administrator, to his credit. And we said, instead, how about we take an intersection that is failing by all accounts, and we'll go in and we'll do interim improvements. And we will take the northbound Jackson Creek Parkway and we'll make a designated turn lane to the east. We will take westbound 105, we'll make dual left turns southbound onto Jackson Creek Parkway. We will take eastbound 105 and we'll give it a designated turn lane to the south on Jackson Creek Parkway, and we'll put in 2 stoplights. Now, that was not the full traffic that the traffic study needed, but because we were able to do that ended up costing us, instead of about our 18%, we've got about 26% that we've spent. And I'll have a cost recovery that in theory someday Monument will repay. Good luck with that. But we took a problem and we have now made it, when we get done this winter, every one of those intersections are going to function at a level of service C or better. They were all an F. My point being that there's opportunity as we go through this process and we study it further. To yours, Commissioner Applegate, about would you consider 4-laning Enoch Road? Of course. Of course we will consider that. Now, there is a rational nexus legal standard here. A property owner can only pay a proportionate share of their impact. But that doesn't mean you can't be smart about how you pay it and how you go about it. And so I would suggest that the traffic, I completely appreciate your concerns. We share them. We don't want to build a neighborhood where no one can get in and out. But allow us to continue down this process. We got to come back to you, and you have another bite at the apple. So that's what I would say about traffic. On the military, first and foremost, we couldn't appreciate our military more. And if those men were still here, I would thank them for their service. And no one wants to do anything to hinder the amazing military institutions we have in this community. With that said, they're not infallible. And I took a little offense at the notion that there was no need for a study until today. Well, that's not true. We've been talking to them for a while. We made our application in December. I've learned a new definition of agnostic, I think, today. Because I didn't read that as agnostic, and it certainly wasn't agnostic at Planning Commission. And when they showed up at Planning Commission and said, we need 2 years to study this, huh? And it just came up. The study that they're referencing, you can check me on this. June 19th was Planning Commission. June 21st, I called Congressman Crank. I sent him the land use agreement that we have with Schriever. And I said, they're saying it's going to take 2 years for them to study this. Crank went and did his thing, and a week later it was funded. It was found in the military appropriations budget. That's the backstory. So I take a little umbrage at that. And more importantly, what did we talk about today? We talked about look angle, illicit drones, height restriction, electrical interference, cyber. Let me address that. They keep calling it an easement agreement. It was a land use agreement. And I asked Blaine to put up on the board the area in pink. It said you will only develop 5 acres. You'll only have 50,000 square feet of building for every 5 acres. You will only have 45 feet in height. You will only have so much electrical interference. This was 1990. They're the same topics. Admittedly, illicit drones probably weren't in the picture back then. But these are the exact same topics. How much more restrictive than 45 feet in height can you get? You can't build a warehouse that functions in less than 45 feet. You can't, that's a standard commercial development height, and a lot of commercial, as we know, goes higher. The landowner made concessions. They entered into an agreement, and they put a 2,620-foot buffer there. And if you then look at the yellow line leading from the pink down to where the Schriever main operations are, it's another 2,600 feet. It's a mile. Let's say this study comes back, and in its most illogical conclusion, it says there should be no development between Peterson and Schriever. What are you going to do? This is not the federal government getting to dictate to you. They're going to do a study, and it's going to have some recommendations. You still have to decide whether those recommendations are going to be incorporated into your code. This isn't the 800-pound gorilla gets to dictate. Please don't hear the wrong thing. We want to cooperate. We have been standing there saying we will cooperate. Blaine and team came up with language that said within reason, within that pink area, if your study comes to some different conclusions than were reached in 1990, we will work with you on that. But if their study says, oh, it goes all the way out to Highway 94, guess what? You're going to buy that property. You're going to take it from me. Not from me, from the applicant. And that's what really needs to be focused on. And I appreciate that they are solely mission focused. And, we're not. We try and balance a lot of different things about what's needed in our community. Economic development, which we support financially and with our time and our treasure. We support schools. We support all kinds of different things, nonprofits. We're balanced community people. We don't want to do anything to jeopardize 7,000 people at Schriever. Now, I would further submit that the odds of 7,000 people moving to Huntsville, Alabama, and leaving Colorado are pretty damn small. I mean, half of them are independent contractors. They ain't going anywhere. We have in front of us a very responsible plan consistent with an agreement that's been in place. And the criteria are the same. The cyber, I don't mean to be disparaging, but that's kind of a rabbit trail. The cyber he's talking about, SCADA. You know what SCADA is? SCADA is the technology that talks to your water and your sewer. And it goes to Cherokee, and it goes to Schriever, and I'm sure they have all kinds of heavy protocols in place on that. Our development's going to have completely different SCADA. They're not even going to talk to each other. So I think there's some of this making it a bigger issue than it is. And we've got a mile, half a mile of ours, half a mile of theirs. Let's work together. And that's all I'd say about military. Relative to the sketch plan criteria.
Mr. Simple, I want to ask you a question about something before we get
Please.
too far. Specific on this land use agreement, because you're far more familiar with these. You said it's not an easement, it's a land use agreement.
It was both.
Okay. Was that a voluntary or was there an exchange?
We did not, that predates the applicant's ownership, but there is talk in it that it was that there was no money exchanged hands, but there was consideration given. People gave up rights, people gave up easement. I mean, it's a typical consideration for an agreement.
Okay, that's what I was just trying to wrap my head around. So it was
No.
at least somewhat a voluntary agreement, which I would assume the landowner did not have to do.
No. And obviously there was probably some benefit to the landowner in gaining some certainty, let's be honest. And I don't know, it was Charlie Ververs a long time ago, and he's no longer with us.
Okay, I will let you continue.
But I'm sure there was mutual benefit. But the last thing I want to touch on is sketch plan criteria. Respectfully, I'd submit that we spent the last 2.5 hours talking about stuff that isn't sketch plan criteria. The sketch plan criteria, as we went through it, is it consistent with the master plan? Yeah. Is it consistent with the place types? Yes. I served on the committee that wrote the master plan. Pretty familiar with it. And this project was an area of change. It was a possible annexation. It was absolutely ripe for development. It was identified as such years ago, 2-3 years ago when we adopted it. It meets all the sketch plan criteria. I will promise you that we will work in good faith, within reason, with Schriever on that study. I have no confidence that that study is going to be done by December or by March or by June. And if we run as fast as we can, I don't think we'd have a shovel in the ground for 2 to 3 years. And we'll be back here at least 2 more times. So with that, I'd close and just ask respectfully that you'd endorse this sketch plan. Thank you. I'd be happy to take questions if there are any.
And I think we have a question from Commissioner Weissong.
Sure, Mr. Stimple. Traffic, great. Those are the kind of things I'm looking for. But you're right. In a sketch plan, master plan, you don't have the ability necessarily to put a lot of detail. But since you agreed with Commissioner Williams, and I agree too with the state, when they just swept clean the CDOT money that was available to get them out of their first level of debt, there's no money available. So how do we look at trying to figure that out? I'm not looking for an answer, but you're absolutely correct. You got to put a lot of creativity into it. But I think that has a lot to do with any kind of a timeline too.
Can I take a stab at answering that?
Sure.
This body has been creative in the past. The Baptist RTA, that was a combination of the county commissioners, the town of Monument, and developers coming together to say, we need to build a bigger interchange on Baptist. And we did it. Woodman Road, combination of the city and the county putting in an RTA there. There's tools that are out there. And while I do think it's regrettable that we never seem to get our fair share of state money, there are other ways of tackling the problem. And so I don't purport to have all the answers, but I do know that there are more tools than probably most people are aware of.
Well, that's good. When you made reference for the agreement in 1990, and you were part of the master plan, both of the joint land use study that was done in 18, there was a 2-mile perimeter around Schriever that you needed to have considerable discussions knowing it was a critical area. So since 2018, that 2-mile perimeter has been aware or been published as being an area of higher importance.
Yes.
To the point where you were part of the writing of the master plan, that then it was incorporated by the El Paso County Master Plan in 21. So for a very long time, that has been an item that needs to be fully addressed.
Can we clarify that though?
Sure.
The 2 miles is where we are required to have Schriever be a referring agency to comment on anything that is proposed. It wasn't a hard and fast line that said no development will occur within 2 miles of a military installation. That was not the language.
I understand. And so I believe you said you filed in December of this or last year. So that kicked this process off. Am I correct?
That's correct.
Okay. So the whole idea is that it hasn't been a very long time that this process has been working. And so making sure that the military has the opportunity to provide the appropriate information as it states in the master plan. I believe we owe them that time to give us the information, since that information has been sitting out there of the 2 mile perimeter knowledge, that, okay, let's find out from them what they're going to say. And then you can make a real educated decision. So I kind of disagree with you on it meets the master plan as far as a sketch plan. I disagree. Thank you.
Any additional questions for the applicant at this time?
Thank you.
Thank you so much. Okay, any additional questions for staff?
I do just have one question for staff, and I think it's in there. There was an extra notation that you'd asked us to add to the resolution. Is that in the resolution in the packet?
Yes.
Okay, thank you. I thought it was, but I appreciate that.
Okay, any additional questions for staff? I do just have one thing I would like the county attorney to clarify for me, because it was brought up previously by the folks at Schriever, addressed a bit by Mr. Stemple, and I'd like to get on the record just so it's clear to us all the actual legal position of if there is a study, if there is guidance that is talked about, as Mr. Stemple said, we are not beholden to that. I just want to clarify with the county attorney that A, if that guidance comes out, it would not be something that we would be required to follow. And B, if there were some suggested guidelines and they were not required, that could be utilized if that nullifies our requirement to protect the constitutional private property rights of those who would own that property.
Thank you, Madam Chair. I would agree with the general premise that local land use authority, as a general premise, won't be trumped by federal guidance. Without seeing what actual guidance might look like, it's hard to go on much more of an opinion than that. But I think that you're correct as far as the overall premise.
And would we still have to, again, would that nullify the property rights of those individuals who could be impacted by that? Or would we still be required to recognize those property rights? And if there were a taking, compensate per the Constitution?
No, ma'am. Private property rights couldn't be nullified by federal guidance.
Thank you. Okay, any other questions for staff at this time? Okay, I will close the public hearing and we will bring it up here for comments and a motion. Commissioner Williams.
Yeah, I do have comments because I really appreciate the needs of our military, the needs of Schriever, the needs of Peterson to have open space around their bases. But I also appreciate the will of this community to get that done through a ballot issue. Because that land is owned by someone. That land must be purchased by someone. El Paso County doesn't have a budget that has an open space fund. It doesn't have a budget that has a buffer fund. We built up a healthy reserve that the state's trying to chip away at with some of their favorite programs. And that's very frustrating to us. And so we have the ability under Tabor And I speak because I'm only here for 16 more months. I appreciate everything Mr. Klein said. I speak more that this is coming probably in front of a future committee for future approvals and stuff, but we cannot afford to take this property from the owner of this property. Yes, we want to protect our military. Yes, we want to protect the jobs here, but we need a dedicated funding source to do that. I had forgotten about the Baptist Road RTA. We have proven our will in this community when we get a grant such as I-25 North between here and Douglas County to step up to the plate, to run a ballot initiative, and to fund the improvements, and to fund it in the way we want without a toll road. Douglas County has a very successful model with their E470 system, which is a toll road. But don't tell anyone I told you that, but it's been hugely successful for 25 years. And so I think we have the ability, because I will agree with you, Peterson Road will be a mess. It probably is already a mess. We have a very healthy workforce going out to Schriever. And that we want to keep that. We want to protect our military. In order to do that, I have no doubt that the voters, that we could sell a ballot issue, or this future commission could sell a ballot issue to get some extra money into PPRTA, or to create an RTA around Enoch Road to do exactly what we need to do out by Schriever. Because we love our military, we will keep our community a military community. And if that requires a ballot issue, we will go out there and do it. But at the end of the day, the applicant has met the sketch plan requirements. This is a sketch plan. It is a step to a preliminary plan. If I were military living out here, I think would be fantastic if I worked on Schriever. So I see this becoming a very, very favorable place to live and to work. And so I just don't see, we have to protect the private property rights of every citizen in El Paso County first. And the importance of that is, yes, one person has come in and bought a very large parcel of land here. And that is a person who owns this property. And I would love to find a way to protect Schriever, but it has to be done at market value. And there is not the money for government to go in and purchase that property. I do not believe in eminent domain for a purpose such as this. It has to be small. Eminent domain has to be very small when we do it. So I am in support of this application. I wanted to tell you those reasons why. I think that, yes, we can be very creative about the roads around this. And I think we can also be very creative about making sure Schriever's interests are protected. Thank you.
Additional comments from commissioners? Commissioner Nelson?
I wanted to read from a slide that was presented earlier by staff that's titled Your El Paso Master Plan. It states, Schriever Air Force Base Suburban Residential Priority Development Area. Growth along Highway 94 is expected to continue over the life of this plan, particularly as operations expand at Schriever Air Force Base. Residential development can support its employees, both military personnel and contractors. Suburban development should be prioritized to help increase density in this area with smaller lot sizes, attached housing, and multifamily apartments. So just in context of the sketch plan criteria that we are responsible for determining if this application meets the standards for that specific item, that is my evidence that when it comes to the proposed subdivision is in general conformance with the goals, objectives, and policies of the master plan. I just wanted to put that on record. I also find that the other criteria listed are also met in this application. And I guess I'll echo Commissioner Williams that the proper role of government is to respect private property and protect individual rights and safeguard our taxpayer dollars and ensure they're being used appropriately. And I just think that if there is truly a risk to national security it's our defense partners that need to give specific guidance, and they have the responsibility and the mechanisms to protect our national interests. And our role here today is to evaluate the criteria before us and determine if the application meets those criteria. National security is a major priority. We have not been given enough information to alter and infringe on private property rights. We have not been a part of those conversations, nor is it our responsibility in this instance. So I will be in support of this sketch plan.
Commissioner Moisong.
Thank you, Madam Chair. I'll strongly disagree with my fellow commissioner. You failed to outline the one item that you just talked about that's bulletized or bolded. Efficient use of land helps preserve open space and reduce impacts on the critical missions being performed at Schriever Air Force Base and adjacent rural areas. There's a reason that it was bolded, because it is a national defense item. What is the primary responsibility of the federal government? It is to protect from foreign enemies. I think it was very clear what they were talking about when you have encroachment. And when Colonel Brogue was talking about his 4 items, that not only the look angle, but the electromagnetic interference, your cyber, and your visual, and then the issues coming in via drones. We know how damaging that is. So the most primary responsibility of the federal government is our protection. Now, yes, we do have guarantees in the Constitution of personal property. So now is the issue of trying to balance that out. My issue right now is that we have the opportunity to wait for Schriever to come back and give us what their information is. And I think that that is the most important thing we can do, because as it was said earlier, if they ran full speed ahead, it's going to be 2 to 3 years before they could ever put a shovel in the ground. If we turn around and give a time period that says if we don't have it by January 1st or January 15th due to the holidays or whatever the case is, then we may have, you know, a different story. But since the national defense is the #1 responsibility of our federal government, and we're basically right now giving Schriever the middle finger. And I don't appreciate that as being a veteran. There's the opportunity to wait and find out what really is required or needed from our military. And I don't see any reason why waiting another 3 to 4 months or whatever it is, when it's so much is at risk that we can't wait. And I'll reserve my right for any final discussion.
I'm gonna add some comments since we've had a little bit of a round, and then we'll come back. So first of all, I want to say respectfully to a veteran on our board, I think that was incredibly arrogant and disrespectful for everyone else who has also served our nation. My husband still serves today, as I said, for 20 years. And there is nobody here giving a middle finger to our military. And I don't believe that of the applicant either. So I think that was incredibly disrespectful. What I do think is that I agree that the criteria has been met. I think it's very clear. The efficient use, I think the reason that was highlighted and pointed out is because when we have more density, it was an argument for more density so that that remaining open space could be there to further support the mission of our military installations. I think it actually means the opposite. The only criteria that I think was potentially addressed in many of the comments that were made has to do with compatibility. And I think that when we typically look at compatibility, we're looking about whether changes are going to spill over onto others' properties that are already there. In this case, we almost have the opposite. It's not that changes are spilling over so much as it's the property that's there spilling on over into everything else and asking them to accommodate them. And while I also believe national security is incredibly important, the reality is something like drones coming down the highway on a semi is not even at play when we're talking about what we're talking about in this particular development. It has nothing to do with a truck full of drones coming down the highway. That's a huge concern for me. And it should be a huge concern, but our primary focus is not national security. We are not the federal government. I am a proud Army spouse today. I watched my husband deploy days after my second son was born for almost a year. I worried every day that there would be a knock on the door or a phone call that my family had given the ultimate sacrifice, so I will not abide any kind of negative comments about my patriotism or anyone else's who has been in that situation. Nevertheless, though my family has given much to the defense of this nation, today, and 5 years ago, I ran for office because I love this nation so much and our Constitution should never be breached. I ran for this office because of my patriotism. And part of that is there is never a reason good enough to violate the rights of a citizen as the government. So to say here today that it is more patriotic to violate the rights of a property owner, to me, is completely out of step. That is our job, is to do that. It doesn't say in the Constitution, you can't, private property rights, unless it's really, really important. We think it's really good. There's a reason why that is there, and that's because the government will always fail to protect those unless it is very clear. In this case, the federal government has the ability for eminent domain. They have the ability, and it is their responsibility. We cannot take on every responsibility. Our job is to remain neutral, to evaluate this based on the criteria, and it is very clear that it has met all of the criteria here today. In relationship to the transportation concerns, I think we have time to work this out. I also think one of the things that hasn't been brought up is I think in the past we have had some federal help even on making improvements to roads, especially when they are related to a military installation. I think I asked the individuals from Schriever if we could work this sketch plan parallel with any kind of potential study or anything that would come along. The answer was yes. So I don't see it in conflict, and I do not see our folks from Schriever saying that that is incompatible with approving the sketch plan today. So for that reason, I will be in support, and I will ask for additional comments. Mr. Wysong.
Thank you, Madam Chair. And there is no disrespect towards you or your husband's service. You made one of my points that I was going to follow up with is, yes, you're right. Eminent domain is an option. We have nothing to do with that. However, I will disagree. When we were sworn in on January 14th, we swore to uphold the Constitution and the state constitution, which then literally applies the national defense. So not to belittle this any further, but I think my point is as clear as I can make it. I will be voting no.
Are there additional comments from commissioners? Commissioner Applegate.
Okay. Comments, and then I think I want to move to a motion if everybody's ready for that. So my comments. You guys just want to make this hard on us, don't you? With that being said, thank you everyone who presented today. Yeah, I want to thank the colonels and the captain and the chief that came in, the men and women in uniform, of course. You know, we appreciate everything Schriever does, our Space Force. Appreciate the developer willing to put forth the improvements to Enoch, like you had said, and work with our military, with our men and women in uniform. That colonel did say he'd like it someday if he was to step outside the base and there was to be some kind of amenities out there. With that being said, I'm comfortable with pushing forward with a motion based on this sketch plan and on this, you know, seeing the criteria that's been laid forward. But I will say this, I do encourage to continue with the developer to please discuss with the base, with everyone involved, with Schriever, what their needs are and what their concerns are. As they are a ghost base. They do have a lot of mission critical. They do have a lot of, they are mission first, and they do have a lot of things they do that are very important to our community and the United States military and the federal government and our national defense. And with that, I'd like to make a motion to approve the sketch plan for Flying Horse East, Phase 1.
Second.
Okay, that's been moved and seconded. I do want to just make sure that additional notation was included. Do we need to include that in the motion?
Oops.
Yeah,
Did I screw that up?
I did not, I'm not sure what that is.
I'm sorry, I'm looking past you here at the clerk to answer the question.
Sorry, Madam Chair. I believe that Ryan said that it was included in the board's backup, so the motion as it stands will be sufficient.
Thank you. Okay, so that has been moved and seconded. Any additional comments? Seeing none, I will call the roll. Commissioner Weissong.
No.
Commissioner Nelson.
Aye.
Commissioner Applegate.
Aye.
Vice Chair Williams.
Aye.
And the chair votes aye. That passes 4-0. Thank you. Sorry, 4-1. Gosh, thank you very much. 4-1. It's been a long day. Okay, we do have a couple more items there here, Mr. Simple, that we are moving on to item 14. We'll be concluding here in just about 2 minutes. Item 14.
Item number 14 is department and committee reports, non-action items, and there are none.
Item 15.
Item 15 is the addendum, and there are no addendums today.
Item 16.
Item 16 is the executive session, and there is no request for executive session.
With that, we've come to the end of this agenda. This meeting is adjourned.